I could forget the memories that can't stay fast, 'cause I have found a path to shed back with heaven and hell. It only takes a spark for a fire to start. Won't hesitate, won't fan the flames, that is the way. We'll make our own future. I'm gonna reach that finish line without a inches at a time. I'll keep going, nothing can stop me. Na 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 na. They say that we're not strong enough, but I ain't never giving up. Gonna leave this future behind me. Na 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 na. I'll keep going, nothing can stop me. Na 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 na.
Well, what happened here? Is my mic not working? Is it not wanting to? Let's see here. Okay. It was just I had the gain down real low. Apparently that's a thing that I forgot to do the last time I was dealing with OBS. I'm still kind of, give me a sec here, I'm kind of setting things up still because Restream does not like connecting with Rumble apparently. Tonight is going to be kind of a chill night where I'll be doing some gaming. How you doing, Manuel? Doing some gaming stuff and going over some of the stuff that we won't get to go into as much detail on the normal show. It's very loosely planned tonight. I'm going to be playing some Advance Wars. I might change up the game. We'll see how I'm feeling. I'm definitely not feeling like showing you guys how much I suck at playing War Thunder or anything like that, so don't get too high on your horses about watching me getting too giddy. But I do have, I think I got everything set up here so I can pull back over and take a look at some things here. I don't want to look at that right now because that'll probably pull down my bandwidth, looking at myself twice. But anywho, so I'm going to be playing some Advance Wars Dual Strikes. I have, to be honest, no audio. Oh, what? Okay, so apparently it defaulted to something that wasn't my mic, so nobody heard any of that. That's fantastic. This is why I love doing live streams, you guys. Can't you tell? So tonight, as the title says, I'll be going over kind of in a lazy live stream some of the stuff that I don't normally, that I don't get to cover during the regular show or cover as much depth as I want to. We got a lot of stuff this weekend that's kind of meme stock stuff. I'm sure we'll go over the Jeff Kurzon filings, but I kind of wanted to go into it and do a bit more detail. There's a couple other things I want to deal with, and I just wanted to kind of play games and enjoy a Friday night. Got a nice bottle of Sapporo. I have not actually drank it, but you know, after watching enough abroad in Japan, I figured I'd give it a try. I'm not a super big beer person, but you know, it's not too bad. Anyway, so I'm going to probably play some Advance Wars Dual Strikes because it's the only Advance Wars I haven't played yet, to be honest. And then I'm going to go over the... Let's switch over to the other window. And then I'm going to be going over the Kurzon filings. I'm going to move this over here for when we're dealing with that. Yeah, that works better on this one. And then... yeah, that looks good there, and we may move it around. I also have preloaded a Sojka, a Sojka video that I might get to because we haven't dunked on everyone's favorite AMC Nazi apologist in a long time, and I like it's Sunday. I just want to relax and punch down a little bit. So if you're not up to speed on the whole Bed Bath & Beyond bankruptcy because you, like most people, are sane and realize that this company went bankrupt like what, it's almost 2 years now? It's 2 years, right? Yeah. And have totally forgotten about it. There's still meme stock morons dealing with it. So the most recent stupidity to hit the docket, as of recent, is that Jeffrey Kurzon. You might know Jeffrey Kurzon from the channel. Let me pull it back up here because I'm pretty sure I got a video of on my desktop, not on my desktop, but on my channel here, of Mr. Kurzon from his time in the Express bankruptcy. I actually don't need to hear it, but you can go to that. It gives a nice little clip show of some of his antics from the Express bankruptcy, just so you know the kind of person you're dealing with. Also, if you've already read The Plan Administrator, he kind of gives in his filing, which I'm sure we'll get into a bit more detail on, because I just kind of want to deal with the idiocy part of it. But down here, he submits the whole transcript, and there's a lot of Jeffrey Kurzon stuff in here with the MJL stuff. Yeah. Mostly what we'll be dealing with tonight, though, is I've managed to set this up so I can actually play it, because since this was a scanned-in document, it didn't originally have it to where you could actually just read it. And I don't want to read it, so I'm going to have the computer read it to me, and every time I find something that annoys me, we'll stop and kind of go over it. Let me switch this over to the headset, because... nope. Close this out. Go over here. The headphones. Cool. Oh, so that's not... I'm going to mute you for a second while I guess I have to reset the whole volume mixer again. I thought I had that set to where I wanted it. Never mind. That apparently was a lie. Mute you. Let me see if that sounds fine. Okay, cool. So that is good. We're actually going to ramp this down a little bit.
Court, United States bankrupt.
Okay. Hopefully that sounds good. You still not hearing my mic? Because I'm showing it's coming through. So I don't know why you wouldn't be able to hear it. That would be really annoying if it was not working. Move this over here for a second. Check something. So, should I turn it up, I guess? Okay, yeah. Does that help? Is this like the gain help with that? I'm glad Manuel's here, because I'd be doing, like the last time I did a video game live stream, I had no idea that my mic was horrible until I saw it in post. Let me check the levels here. Ah, that'd be why. What about now? I bet it sounds really good now. Yeah, because I hate it. Because I hate it when Microsoft decides that it's going to, in software, turn down my mic. I didn't ask for that, Windows. I didn't ask for you to turn down the levels on my microphone in software. So don't do that unless I tell you to. Okay, better, good. So anyway, we're going to be listening to. I think it's going too loud a bit. Let me just knock it down here a little bit. Okay, so that should be good. So I'm going to be playing some metallic sound. Interesting. Well, we'll just, I guess, have to roll with it for right now. I'm going to be spending all evening fucking around with my mic is what's going to happen. So we're going to let this play out. In fact, I'm going to let it skip past all this crap. We'll get straight into the filing.
Case 23-13359 VFP Doc 4100 and
I assume that's coming through fine. So
4150
Switch
filed
over
June
this.
13th, 25 entered June 13th, 25, 1354 and 19 seconds desk main document page 3 of 21. United States Bankruptcy Court. District of New Jersey. Caption in compliance with DNJ LBR 9004L.
okay, we can skip over that.
Equally uter 11 USC I 123, A, 4,
Keep going.
and that the number of shares
There we go.
cancelled did not exceed or otherwise differ from the number actually authorized and / or issued. This motion is not about personal recovery.
He says,
It is about procedural integrity,
sure.
transparency, and the preservation of estate credibility in a system already plagued by structural opacity in the share reconciliation process. What stands before this court
Okay,
is not.
let's just make it clear here. And I know Manuel already knows what the situation here is. Like, the share reconciliation, there's like nothing to be reconciled. Your shares don't exist anymore, dude. They don't exist. They have been canceled, deleted, liquidated, whatever, like, describing adjective or statement that you want to make about them, they don't exist anymore.
Not just a request for routine clarification, it is a moment of reckoning in what may ultimately be recognized as a scandal greater than FTX or Meta.
Ooh, we are reaching for some major league hyperbole. Does it let me highlight it? Oh yeah, excellent. Greater than FTX or Madoff. This is the exact same hyperbole I remember from when he was in the Express bankruptcy. Like, this guy goes full speed hyperbole and does not slow down.
Madoff. The rot affecting U.S. capital markets, fueled in part by synthetic dilution, rehypothecation, naked short selling.
Oh, Jesus.
Captured regulators and the erosion of investor protections since the 1999 repeal of Glass.
All same stuff we're used to.
Seagull has now reached the doors of the bankruptcy system and this court. Movement has presented verified DRS holdings, a documented pattern of ignored or deflected communications,
so this is all...
and the plan administrator's refusal or
yeah,
failure
I know
to
how to
examine
play the game. Can
the
we...
AST/annuity ledger, despite a fiduciary obligation to do
need your
so.
help.
Movement was listed in DKT number 219 from May 2023, the last known publication of the shareholder ledger, and is still only labeled as purported former shareholder. The motion was timely
Yeah,
brought
because your shares
before
don't exist anymore.
distribution, and yet has been met not with cooperation, but with hostility and mischaracterizations, including a request for sanctions that seeks to pooish transparency. Rather,
I love that the voice translator did a really great job with punish. Yeah, the reason why you're not being mischaracterized, dude. Number one, again, your shares don't exist anymore. Number two, yeah, he's tired of people like you and the bunch of other these clowns that have come into this lawsuit trying to basically waste the court's time, waste his time, waste money for what little money they have. Remember the last time we talked that there was a potential that they couldn't even pay any of the creditors, and like that it was administratively bankrupt. They couldn't even pay the administration fees. And some things have changed since then because we have had the settlement and the lawsuit for against the board for the share buyback stuff and a few other things. But yeah, there's a really good chance that even the unsecured creditors are getting jack shit. They're not going to get a single thing in this bankruptcy. So yeah, you wasting the court's precious time and the estate's precious resources, yeah, definitely grounds for sanctions. Definitely why the plan administrator has zero fucks and zero time for you.
rather than support it, these facts, taken together, suggest either gross negligence or an active effort to Avoid confronting discrepancies that could expose broader structural failures, possibly even fraud.
Glad you got the
If
pro.
these issues
Oh,
are not addressed,
going back to that chestnut of accusing the the plan administrator of fraud. Yeah, we're really going to great places here.
addressed by the court, it risks more than a miscarriage of justice in a single case. It risks undermining faith in the Chapter 11 process itself. 4. Case 23-13359 VFP Doc 4150 filed June 13, 25 entered June 13, 25, 13:54 and 19 seconds desk main document page 5 shielding those who profited through unlawful means and
Citation
silencing
needed.
those attempting to
Oh
Preserve
man, did I delete the citation needed box? Oh, I did. We'll come back to that later.
preserve integrity. Reply point I. Movement has standing to raise this issue.
No, you don't.
While the plan administrator argues that all shareholder rights were extinguished
They were.
upon plan confirmation, comms have held that former stakeholders may retain standing to seek enforcement or clarification of confirmed plan terms, particularly when discrepancies affect equitable treatment of a class. Movement does not seek distribution, damages, or relief under 11 U.S.C. 1144
Well, it's good because you
or
wasn't
Rule
getting any.
60b. Instead, Movement asks this court to compel a verification of facts that affect the fundamental fairness, constitutionality and internal consistency of the plan's execution as to Class 9.
They're like that
Movement
whole
has-
thing again to Class 9. You're not getting anything. Your fairness and your equitable consistency, like fairness or whatever, it's already been adjudicated. Done.
Has Article 3 standing because he has suffered a concrete and particularized injury traceable to the plan administrator's refusal to
No.
reconcile Class 9 equity interests.
Yes, you've already been reconciled. Like your shares are gone. Like I don't know how many times it's gonna need to be said. Your shares are gone for this to be like get it through their heads.
Interests, and this could one has the power to redress that harm, as recognized in INRI. East Coast Foods Incorporated, 66F.4th 1214, 9th Sir 2023, constitutional standing governs such matters, and Movement is an aggrieved equity holder under both constitutional and statutory standards.
No. Like, I love when people throw out citations but don't actually show how it's applicable. Like, what is this? Let's go to case mine and see if we can find something here. Because, like, he doesn't even, like, the issue isn't, like, the issue isn't that standing doesn't exist. Because, like, no kidding, but you haven't proven the elements for determining standing and then shown how they apply to you. This is just a blank assertion that this citation agrees with me without explaining in any way how it's relevant here or in what way it helps your case. And again, with another blank citation right after it, see Jones Day Ninth Circuit Standards, like, okay, cool, you know how to find citations. Great job, my dude. Oh, sorry, you probably have to see the highlight. That'd probably help. But like cool. I mean, but what do these citations mean to your case? Like, what is the standard for review for determining standing, and how does it, like, in what way can you prove that you have actual standing? Because since you have no shares, you have no interest in the estate. Nothing will be given to you. Your claims are dead, so you have no standing. That was the point of the plan, man. Oh man. Wait, a raid? Oh dear. I'm getting raided on Rumble of all places. I'm a little speechless. 'Cause that was the last place I expected something like that. I can't, man, I hate that Restream, when you're doing it from OBS, doesn't allow you to show comments like you would if you were just normally doing. Oh well, so I get stop. Not a whole lot. We're going over bankruptcy stuff while playing Advance Wars. We get to listen to meme stock. I'm basically going over meme stock idiots trying to sit their way through bankruptcy court. It's comical in a sort of, I don't know if it's your thing, but it's definitely my thing. Oh my goodness.
Standards. C. Jones Day, Ninth Circuit, Standard for Constitutional Standing.
Oh well.
Applies to bankruptcy appeals, September 22, 2023.
https://www.jonesday.com/n/insight/20233/09/9-standard- for Do not play over that link. Just kind of
express rights under the plan itself. DKT number 2160, which states in part, on the later of the effective date and the date on which distributions are made pursuant to the plan, if not made on the effective date, except for the purpose of evidencing a right to and allowing holders of claims and interests to receive a distribution under the plan, shall be deemed cancelled.
Yep.
See Article 4. 5.
Yep, it's right there. It's funny because he has it cited like right there, that on the later date of the effective date and the date which the distributions are made pursuant to the plan, which means we're talking about the bankruptcy waterfall, that your share interests are deemed canceled. Like you get nothing. You lose. Good day, sir. I should have had that meme ready if I was going to whip it out, but there you go.
5. Case 23-13359 VFP Doc 4150 filed June 13, 25 entered June 13, 25, 1354 and 19 seconds desk main document page 6 of 21. Means for implementation of the plan. Section D cancellation of
getting
notes,
S rank on the first mission of the game.
Documents.
Way to go, Sean.
Made abundantly clear through detailed
You're
documentary
doing so
evidence
awesome.
attached to his motion and 2 supplemental filings, that he held 58,008 directly registered shares of common stock through
Who
AST,
cares how many shares you held?
AST,
You hold
now
0
Equinity,
shares now.
and over 3,000 additional shares via various Wall Street brokerage accounts at the time of cancellation, the plan's effective date of September 29, 2023. Yet, before even entering the preliminary statement in their voluminous 112-page opposition, comprised in large part of irrelevant transcript excerpts, counsel for the plan administrator describes Movement as someone who merely purports to be a former shareholder.
I mean, yeah, because you don't have any shares anymore.
Is it frivolous to not at least see DKT number 219 where Movement's name is clearly listed? How could four such esteemed attorneys use this circular logic and be so flip with words if not done maliciously? Such language is not only inaccurate and inflammatory, but emblematic of a disturbing pattern that warrants sanction against the plan administrator and his counsel.
What?
Pashulski, no less than 4 attorneys with their name on the opposition. Rather than perform their fiduciary duty to consult the shareholder ledger as of the effective date, counsel has instead chosen to cast aspersions on a licensed attorney and officer of the courts of the Southern and Eastern Districts of New York, the Second Circuit Court of Appeals.
Oh, cool! You're
States
licensed in
Supreme
a
Court
state
by
court, so you can
fabricating
do
his
federal
status,
stuff. Like, who cares?
Helping to their online ridicule. That is gaslighting.
I think you kind of,
not
did that to yourself, bro. The online ridicule by filing this frivolous motion before a bankruptcy court after the plan was already actuated. Way to go, dude! Like I could throw tons of money into stupid stocks and then lose all my money, but and if I get mocked for being that on the internet, that's kind of my fault. Like, you do stupid things, expect to be called stupid. I don't know what you want there, bro.
Advocacy. Movement does not claim to be a bankruptcy expert, rather, he likens himself to the...
If you aren't a bankruptcy expert, then what are you doing filing into a bankruptcy docket? If you admit that you're an idiot, just stop and walk away. And then maybe you won't be called an idiot.
Himself to the little Dutch boy, trying to hold together the dam of justice while simultaneously...
The dam of justice.
Case 23-13359 VFP Doc 4150 file
You're
June
gonna make
13,
me-
25 enter June 13, 25, 13:54 and 19 seconds desk main document page 7 of 21. Learning complex bankruptcy
I
law
did.
and balancing
It's
real-life
in the...
obligations. Nevertheless,
Am I going to be stuck in this
legal
because...
issues raised are fundamental. How can any purchaser of the estate pay superior classes of creditors 100% and distribute the remainder to shareholders if the question of who qualifies as a share...
Because it's irrelevant! It's irrelevant, my dude. Like, that's how the bankruptcy waterfall works. That you pay the senior creditors first, and then you pay the junior creditors, the unsecured creditors, and then the preferred shareholders, and then the shareholders are at the very bottom. They get paid last in the bankruptcy. So yes, they get paid first 100%. And if they get anything less than 100%, guess what you get? 0. So it doesn't matter about determining anything about the shareholders. It's already been determined that you get 0. So guess what? We don't need to ask any of these questions about shareholders or what they're getting or any of this crap. It doesn't matter. It doesn't matter. Since you get nothing, why do we need to do anything about this?
Shareholder is
Other than to
undefined
make you
and
feel
undetermined.
happy.
Instead
I don't
of
know.
cooperating with a fellow officer of the court, who has clearly expressed willingness to engage with discretion and professionalism, counsel has opted to
I don't know about
obscure
discretion.
basic truths and deny a reasonable due process request by someone who lost
You too, sir.
approximately
night.
$20,000 investing in the debtor. Rather than clearly define what constitutes an allowed interest under the plan, or reconcile why the record reflects cancellation of only 70 million seed-held shares but...
Okay, see, we finally have gotten to the point where he has his little gimmick here. He thinks that not all of the shares have been canceled. That is his big thing here. Rather than clearly define what constitutes an allowed interest and that only some of the shares that were held in AST, no, actually all of them were canceled, dude. All of them were canceled. All of them were liquidated. They do not exist anymore. I don't know what other fairy tales that you want to believe in, but they're wrong. They're very, very wrong. So, best to luck to you in your senior
No
year.
corresponding evidence of cancellation of directly registered shares at AST/Equinity. Counsel seeks sanctions. Movement respectfully submits that this proceeding cannot reach a fair or lawful conclusion so long as basic facts concerning Class 9 equity interests remain withheld. The plan administrator's continued refusal to clarify the total number of outstanding shares, despite repeated good faith requests, undermines both constitutional due process and the statutory obligation to maximize...
You already had your due process. Where were you when the plan was being approved? Where were you during the entire beginning of the first, before, during the beginning of the bankruptcy process? Where were you during the rest of this? You seem to know how to show up into bankruptcy court. You did it during the express bankruptcy. So, too late. Too fucking late, my dude. The plan's already being approved, and it's being executed. And in that plan, shareholders get 0. Because Bed Bath & Beyond was super fucked. Super fucked.
Maximize estate value under the bankruptcy code.
Do we need to get back out the balance sheet?
Example, if a hypothetical acquirer were to satisfy all creditor claims and offer one share in a reorganized entity, NewCo, to each valid equity interest holder.
Except that's
or
not.
one for
We already know that's not going to happen. We already know that there is no NewCo. There's like this what if game you're playing. We like if there's a why did it do that? Why did it do that? That's dumb. Don't do that. Like we already know that your hypothetical is pointless because it ain't fucking happening. The plan already exists. Why do you think that the guy that you're trying to argue with in front of the judge is called the plan administrator? There is already a bankruptcy plan, so we don't need to play these stupid fucking hypothetical games. It doesn't matter. It doesn't matter.
4-7 or any other ratio a purchaser deems worthy, such a distribution could not occur unless the identity and number of those holders are known and verified. The logical inference is troubling. By resisting basic transparency, the plan administrator and his counsel appear. 7. Case 23 to be posture.
Oops, that's not
to be undermining the case 23-1
There we
to
go.
be undermining their fiduciary duties
Nope.
to the estate and this court and foreclose.
Like he doesn't owe you any more fiduciary duties anymore. Like again, equity holders don't exist.
Foreclosing the possibility of any meaningful reorganization or restitution to shareholders, a detriment to every Class 9, not only Class 9. Movement cannot identify any good faith basis for this posture.
Yeah, he can. It's called the bankruptcy waterfall.
Posture. Attached hereto as Exhibit A is a timeline and brief summary of movements. Communications with counsel for the plan administrator.
Oh boy.
These communications may be.
Wait a second. Let me look back here and see. Is that actually attached here? Oh, it is. Well, we don't get the actual conversations. We just get a Excel spreadsheet of the conversations and like little so you're not going to give us the actual conversations. Real helpful there, Slick. I maybe it's just me, but I wouldn't take your word for what
to be
happened.
undermining their fiduciary duties to the estate and
Yeah, we got
to
that
every
already.
posture. Attached hereto as Exhibit A is a timeline and brief summary of movements. Communications with counsel for the plan administrator. These communications may be protected as privileged under Federal Rule of Evidence 408 and /
Oh, he's saying it's privileged. Okay. Now, okay, that makes at least a little bit more sense. He's saying it's privileged, so he created a privileged log. I mean, okay, I guess. That doesn't make much sense to me, but sure, whatever, I guess. If you want to say that, I suppose you can.
Work product. Movement expressly reserves all rights and will bring hard copies of the full record
I'm sure.
to the hearing scheduled for June 17, 2025, for in-camera review, should the court wish to examine the pattern of deflection, gaslighting, and non-responsiveness that has frustrated Movement's efforts to obtain a simple, verifiable answer as of the plan's effective date.
It's already
How
effective.
many total shares were
He said
canceled,
as much.
and who held
Who
them and
cares?
where? Reply.
Who cares? They were canceled. Who cares when or how many? At this point, it doesn't matter anymore. It really doesn't.
Point 2. The motion is procedurally proper.
It really
Proper.
isn't.
Contrary to the plan administrator's assertions, this motion is not a discovetti request within an adversary proceeding, nor does it rely on subpoena power. Rather,
It does.
it is a post-confirmation request for clarification and implementation, firmly grounded in this court's inherent equitable powers. Bankruptcy courts retain jurisdiction to interpret and
It is discovery, though, because he's asking for a full accounting of everyone who was a shareholder. And I don't know if anyone knows, but companies don't keep lists of beneficial shareholders. All they know is Fidelity holds X amount of shares. You know, like that's all they know. Webull has this many shares. Robinhood has this many shares. They don't know the individual shareholders. They don't. So that would require discovery and going to each individual broker and being like, okay, you have 100,000 shares. Who owns them? Who of your customers owns those shares? That is discovery, my dude. You're a lawyer. I shouldn't be having to fucking explain this to you. I'm at best, you could say, a paralegal. Like this is shit you should know. Like this is law 101. I don't know what's got you locked up in here that you just can't grasp what's going on.
Enforce the terms of their own confirmed plans, a principle the movement has seen applied. Directly in INRI Express Incorporated, No. 24 to 10831, KBO, Bankruptcy Dell, where Judge Owens confirmed a plan that unambiguously cancelled all existing equity interests, not merely allowed interests as appears to be the case here. See Express DKT number 1130 at p30. It bears emphasis that the structure and record-keeping of U.S. capital markets are susceptible to manipulation and systemic opacity, a concern addressed in movements. 8. Case 23-13359 VF motion in connection with recent CFTC staff suspension. CDKT number 4126, Parad 21.
What does that got to do with anything?
Ignored by the
what does the CFTC got to do with anything? Hey, are you still there, Manuel? Maybe you could fill me in on what the frick the CFTC has to do with the cotton licking of any of this?
Administrator and his counsel despite their duty under the plan to investigate third-party claims held by the debtor. Although Express S. Notice of effective date was issued on December 31, 2024, Movements expert shares QZIP 30,219 times 10 to the power of 202nd, still appear in his brokerage accounts today.
Who cares?
2025.
Who cares? Like the law, the ruling that was the plan for your express bankruptcy is done. It like the plan was approved. So like who cares about your ghost in the shell shares that are worth zero? Like eventually they will be cleared out by your broker, but like for all intents and purposes to the rest of the world, they are worth nothing. You can't trade them. They are gone, deleted, like same as your Bed Bath shares. They don't exist anymore.
Information and belief are more likely than not still reflected on the ledger maintained by the transfer agent, computer share. 2. Unlike in INRI Resorts International Incorporated, 372 F.3D 154, 3D Sir 2004, where the post-confirmation trustee lacks standing due to the plan's failure to expressly retain claims, movement here brings this motion pre-distribution as a party in interest under 11 U.S.C. 1109, b, the provision guaranteeing the right to be heard in Chapter 11.
You're not a party in interest though, because your shares they don't exist anymore. The plan said Class 9 is not expected to have any distribution. They are deemed to reject the plan. Their interests are canceled, liquidated. They don't exist anymore. You have no standing.
Proceedings. Movement is not asserting new post-confirmation claims but is instead seeking clarification of Class 9 treatment in order to maximize estate value for all classes and ensure a fair and accurate reconciliation of the shareholder ledger. Where there is evidence of inconsistency between the public float and seed and co.
There is,
and where at least 58,000
there's an inconsistency between you and your loony conspiracy theories.
And likely about 81 million more, were omitted from cancellation schedules. It is both 2 Movement is currently engaged in discussions with ComputerShare after being locked out of his online shareholder account for declining to accept a revised online user agreement containing an irrevocable power of attorney. This incident highlights a broader and growing problem. Household investors face increasing barriers to accessing and managing their own equity holdings. The issue is relevant.
Oh my goodness.
Here.
Yeah, I forgot about this. This is a funny part when I was reading it, before I went live here. This part, we're going to have to zoom in a little bit here. But, Movement is currently engaged in discussions with ComputerShare after being locked out of his online account. His online shareholder account for declining to accept a revised online user agreement containing an irrevocable power of attorney. Well, that's how it works. If you choose to do business between you and an entity, or a company decides to make an entity in charge of its shares that are distributed, whether that be, some sort of DRS agent or whatever have you, you have to deal with them. Being able to participate in equity markets isn't a right. So if you don't follow the terms, then you don't get to trade in equity markets. Sorry, not sorry. Welcome to capitalism, bitch. I don't know what to tell you here. One instance, meme stock people like to LARP as free market capitalists, but when you get down to nuts and bolts, they want special privileges. They want to be treated differently than everyone else, and they think that they're special snowflakes who get special privileges because they're extra special. Don't you understand?
Here, as it reflects the same opacity and confusion over what constitutes an allowed interest, and illustrates the larger structural challenge of asserting ownership rights in a fragmented and institutionally dominated market. Movement submits this note as an example of the burdens imposed on good faith household equity holders seeking return on investment, burdens compounded when a plan administrator seeks sanctions against them for simply asking.
It's not sanctions for simply asking questions. It's sanctions for filing a motion on the document that he now has to spend resources and pay people to respond to. Resources that could go to creditors. Do you see how you're wasting his fucking time makes things worse for everyone? That is the problem here.
Asking the court to 9. Case 23, reasonable and prudent to seek judicial clarification before Class 9 is irreversibly disenfranchised.
It's already, I wouldn't use the word disenfranchised, but it's already irreversibly changed. There is nothing else you get to do, my bro. Your shares are gone. They're not coming back. Your shares are gone. No, that's not what I want to do. Okay. Let's get you here. You there. Join. There we go. Join. Yep. Move right there. Bring you here and wait. Okay. Yeah, that's good. Alright, back to this idiot.
Disenfranchised. The plan administrator's argument that Movement lacks standing under 1109(b), because his interests have allegedly been cancelled, misconstrues both the law and the nature of the relief sought.
No.
It also disregards Movement's constitutional rights.
It doesn't. This is the way the bankruptcy law has been established. And if you think you have some sort of constitutional argument, go ahead, appeal. See how that works out for you. I would love to watch you try and get certiorari out of the Supreme Court. This has been well-established law. Your constitutional rights have not been violated. You had your due process. Your due process was the entire process up to and including the plan and the ability to object to the plan, which is Neely Das was the only one who went to try and appeal the bankruptcy plan. Like, you had all these chances, and guess what? You didn't take them. And now, all of a sudden, 2 fucking years later, you want to try and do something. No, it's not how that works.
Rights, including, but not limited to, due process. The opposition asserts. In contrast, here, because Mr. Kurzon's interests have been cancelled and extinguished, and the express terms of the plan state that he is entitled to no recovery, he no longer has a financial interest in these Chapter 11 cases.
That's how that works.
DKT
That is indeed how that works.
4146 at 16. This reasoning is circular and unsubstantiated.
It is not circular.
It presumes that cancellation has occurred in order to argue that movement lacks standing.
Yeah, cancellation does end that whole conversation. Like, that is how that works. Your shares have been canceled, therefore you were done. That conversation is over with.
Standing, while refusing to produce the very evidence, namely
like, he doesn't need to produce any evidence. Like, the bankruptcy plan is the evidence. In the plan, it says your shares are canceled. Your shares are canceled, you have no standing, have a nice day. That's how that works.
Evidence, namely the AST/Equinity shareholder ledger that could confirm or refute that premise. Worse,
that has nothing to do with the ledger. Like, what part of your shares are canceled is too hard for you to grasp.
Plan administrator's threat of sanctions appears less grounded in law than in deterrence, aimed at silencing the
no, it's grounded in law, and you just don't like
plausible
it.
Concerns about unequal treatment and systemic irregularities in Class 9. If counsel is so certain that Movement's interests were cancelled, they should welcome the opportunity to
No! Because every time that he has to waste his time with your frivolous, you and everyone else's frivolous arguments, is money and time. That time in front of the court that costs money. Time and for filings that requires payment that could go to the creditors who are in front of you in line. That's why he's really pissed about having to waste his time with losers like you. That's money that could be going to the people in the bankruptcy waterfall under the law that it should be going to.
Confirm that fact through full ledger disclosure. Their ongoing refusal to do so undermines the plan's integrity and raises serious
questions. It really
about
doesn't.
Compliance with 11 U.S.C. L123, A, 4, and 1125. The plan administrator's tell is that he called a fellow sworn officer of the courts, Movement, who is bound by an oath and a duty of honesty before all tribunals, a purported shareholder, implying he has failed to even inspect the shareholder ledger, and neglected a second check of DKT.
Why do we keep coming back to this? Like, what is, like...
May imply
I get it. Your ass hurt that he called you an alleged shareholder, and you don't like that because it makes your fee-fees... It hurts your fee-fees that you don't like that. Well, too fucking bad.
Basic investigation into securities fraud on the estate, a claim that should benefit creditors, has not even begun where statutes of limitations...
Because there's no proof.
As shown in Exhibit A, Movement made numerous...
Like, this same sort of horseshit was brought up during the Sorrento bankruptcy. And you want to know how many naked shorts or bad actors Wes Christian found? 0. And equity holders got wiped. And now he's trying to do the same sort of thing in the metamaterials bankruptcy. You know how many naked shorts they're going to find there? 0.
Good faith attempts to resolve these questions without court intervention. At every turn, Movement sought clarity and transparency, not conflict. It is precisely because those efforts were met with silence or evasion that judicial oversight is now both warranted and necessary. Reply point 3, the plan administrator has not denied the share count discrepancy. The plan administrator devotes considerable attention to jurisdictional and procedural defenses but fails to meaningfully address the core issue at hand.
Because it's irrelevant and it's moot. Like, this is a guy who has investigated the swing trade stuff with Ryan Cohen, the board of directors, and their whole share buyback thing, and got a settlement on that, is currently going after Hudson Bay Capital over its death spiral financing. If there was actual evidence of any sort of malfeasance for which Jeff Curzon's talking about, you don't think that the plan administrator would have explored that? The reason he's not wasting his time with it is because he knows it's a fruitless waste of the estate's resources. And the reason why he's not giving you the time of day is because he knows it is a fruitless waste of the estate's resources.
And the apparent discrepancy between the number of shares reported as held by Seed & Co. as of the effective date, approximately 701 million, and the total number of issued and outstanding shares, which the debtors own 8KDKT 4127, attachment L confirms to be 782,005,210 as of July 20th, 2023.
Who cares?
The debtor's September 14, 2023 Form 8K signed by Executive Vice President and Chief Legal Officer David M. Caston states that the company has no preferred shares issued or outstanding and has 782,005,210 shares of common stock issued and outstanding as of July 20, 2023. On the effective date of the plan, all of these shares will be cancelled, released, and extinguished and will be of no force or effect pursuant to the plan.
Yep.
This filing is problematic on its face.
Why?
It references a share count from nearly 2 months prior to the effective date, provides no reconciliation or update for intervening activity, and introduces uncertainty rather than clarity. Even more concerning is that approximately 701 million shares were recorded as cancelled, primarily those held in.
Jesus, is this what he's going for? Because they didn't put the exact share count in the plan. That means that those shares weren't canceled. That's so unbelievably fucking stupid. Is that seriously his argument? Even more considering approximately 700, because there was so much death spiral financing going on that they liquidated all the shares so fast that Bed Bath literally could not keep up. 701 million shares that were recorded as canceled, primarily those held in the street name via C&C Co. Yet the remaining 81 million shares, including, who cares? The plan said that the shares were canceled. That, all shareholders, all equity holders were put into Class 9. Class 9 shares and equity interest was canceled. And so you're going to play these semantics games about what the share count was, and therefore my shares weren't canceled, bro. I'm sure that'll work out really well for you in court.
In street name via Seed & Co. Yet the remaining ST million shares, including movements. 11. Case 23-13359 VFP Doc 4150 filed June 13, 25 entered June 13, 25, 1354 and 19 seconds desk main document page 12 of 21. 58,008 DRS shares at AST/Equinity, appear to have been omitted from the cancellation record. Compounding this confusion is the unannounced appearance of 170 preferred shares and warrants, absent from the plan or any disclosure under 1125, that were nonetheless included in cancellation schedules. If such preferred equity and warrants TRNLY existed, the plan administrator has an obligation to disclose their issuance and legal
No.
basis. The record is incomplete and internally inconsistent. Movement is not alleging fraud, but is raising a facially valid concern about whether all Class 9 interests were properly and equitably extinguished.
Yes, they were.
Extinguished. This is not a personal grievance, but a systemic
Oh.
inquiry.
Really?
Grounded in 11 USC
Like,
109.
let's be honest here. If you have to lampshade that in a filing, chances are that that's not the case.
109. B. The U.S. Constitution's guarantee of due process, and this court's inherent equitable powers. If the estate cancelled fewer or more shares than were ever legally issued, the resulting discrepancy implicates the rights of all Class 9 stakeholders, not just movement, and requires judicial clarification.
Not
Such
really.
relief need not undo the plan, but may instead serve to preserve its integrity and ensure compliance with 11 USC L.
It's already in
123
compliance.
A, 4, so that no
I know you
equity
don't like
holders
that,
are
but-
arbitrarily disenfranchised or treated unequally. It is worth
They're all being treated equally because there's not enough money to come down for shareholders to have an interest, to have any recovery. So you already have you're being treated equally. You know, Class 9 gets nothing. You're all getting the same thing.
How can any future recovery, whether in cash or equity, through a reorganized entity?
Dude still thinks he's getting shit. Whether in cash or equity or through a recognized entity such as Nuco, not happening. None of those three things are happening. It's not happening. That's a falsehood. He made it up. And why does it do that? What the hell? He made it up. Not happening. None of that.
Entities such as Nuco be lawfully and fairly distributed if the identity and number of rightful Class 9 beneficiaries remain undefined.
There are no
This
Class 9
lack of
beneficiaries.
Clarity threatens not only equitable treatment for Class 9 but also the enforceability and legitimacy of any post-confirmation value realization. Creditors and state attorneys general take heed, if the beneficiaries of cancellation cannot be identified, then any 12. Case 23-13359 VFP Doc 4150 filed June 13, 25 entered June 13, 25, 13:54 and 19 seconds desk main document page 13 of 21. Future recovery whether via litigation, clawback, or Nuco equity risks being tainted by procedural infirmity and subject to legal challenge. Promoters
Is it
online
because,
take heed as well, shouting we won while mocking the
Oh yeah, I forgot about this. There's a nice shout out to Pee Pee here.
movement is not only premature, it is revealing. Movement is a long only,
Oh, here we go.
pro SE Class 9. Shareholder pursuing truth and transparency first, and any rightful recovery second. There can be no meaningful exit without a clean and verified cap table, something any legitimate acquirer would require to distribute equity or cash in compliance with
There's
bankruptcy
going to
law
be no
and corporate
distribution
governance
class nine.
standards.
Sorry.
Reply point 4. This motion is not frivolous and should not be sanctioned. The
Cool
request for sanctions is
story,
unwarranted.
bro.
Movement has participated respectfully and in good
And
faith.
that's irrelevant. It's irrelevant if you've been respectful. Like the point is that you've wasted the estate's time, and as previously stated, each moment of time being wasted is stuff that could be devoted to things that would actually bring recovery to people who actually have an interest in this, meaning the creditors. And more expenses being put on the estate is money being taken away from the creditors who are higher up on the waterfall than you. So, yeah, that's why he wants sanctions. You're going to waste my time and resources, which means you're going to waste the time and resources of the estate, which means that for me having to deal with you, I'm going to take money out of your wallet so that way it doesn't harm the creditors. Have a nice fucking day.
Reconciliation of share data in a case with public interest and systemic implications is not harassment, it is diligence.
Irrelevant.
The estate should welcome transparency as a foundation for closure. Given the gaslighting, obfuscation and improper use of Rule 11 against movement, movement respectfully asks that the court grant movement his costs, not to be paid for by the estate, but by the Lawfin Pashulski in an amount to be less than $1,000, printing, postage, car rental.
Yeah, that's
gas,
also not
parking,
happening.
hotel.
You're the one who decided to waste your time. You will bear your own expenses.
It would have been much easier for all parties and the court, and more beneficial to all classes, had Pashulski just entered into a formal or informal NDA with movement and answered his questions and corrected the record.
Nope.
Such as movement offered by settlement. Instead, it appears that Pashulski is deliberately hiding the shareholder list and protecting who knows what.
You're not a,
it does not seem to be
you're not a person at interest. Like equity shareholders, they're like Class 9 was canceled. So guess what? You don't get shit.
Value of the 13. Case 23-13359 VFP Doc 4150 filed June 13, 25 entered June 13, 25, 13:54 and 19 seconds desk main document page 14 of 21. Estate for Class 9 or any superior class if they do not offer equal treatment under 1123, A, 4, or good faith communications with members of Class 9. Reservation of rights regarding online disinformation and digital misconduct. Movement respectfully submits that, since raising concerns about systemic share irregularities in both Judge Owen's courtroom, in Re-Express, and in this proceeding, he has been subjected to what appears to be a coordinated campaign of defamation, harassment, and deliberate digital disinformation by anonymous accounts. These efforts...
Really? What? Coordinated campaign of defamation. You know what? I wonder if, like, since I did a lot of his stuff, like the stupidity he was doing in the Express bankruptcy, I wonder if he considers me one of those people delivering defamation harassment via anonymous accounts. Well, you don't have to worry about identifying me. The AMC fucking clowns did that, so bring it on, bro. There isn't a single thing that I haven't said about you that isn't true. But you're a fucking idiot and have no idea what the bankruptcy law is. You even admit as much. So, yeah. Maybe stop being a soft sit, bankruptcy soft sit, and you wouldn't have these problems.
Efforts may be traceable to individuals or entities with a direct or indirect financial interest in concealing material irregularities or discouraging shareholder inquiry. Movement expressly
cool story,
reserves all rights under law to identify pseudonymous or anonymous actors and to pursue all available remedies against those found to be acting maliciously, fraudulently, or in furtherance of market manipulation or estate misconduct. These tactics threaten not only Movement's reputation and physical and mental well-being but also the integrity of the reorganization process itself, and they risk chilling participation by other pro-SE or minority stakeholders. Intimidation, misrepresentation, and coordinated disinformation. Campaigns must not be allowed to succeed where transparency and due process are
not sure what that has
required.
to do with frickin' anything.
The online vitriol including seemingly coordinated posts on platforms such as 1,1111. Reddit and X frequently misrepresents Movement's identity, motives, and legal standing. These attacks appear designed.
No. If the plan administrator hadn't made it clear, we know what your legal standing is, and it's not what you think it is. Bad actor or plant. Oh, okay, so he's just talking about the Bed Bath &
Designed to
Beyond
cast
people.
Movement as a bad actor or plant.
I just
despite
think
the
you're an
fact
idiot.
That he has at all times acted in his own name, in accordance with this court's procedures, and consistent with
Well,
his
that
ethical
sounds like
duties
he's
as a
casting
licensed
shade at
attorney.
MJL.
He has complied with all. 14. Case 23-13359 VFP Doc 4150 File June 13, 25 Enter June 13, 25, 13:54 and 19 seconds Desk Main Document Page 15 of 21. Applicable disclosure requirements and taken proactive steps to clarify any perceived ambiguities. The suggestion that this motion is frivolous or malicious is not only unfounded, it
Is it
appears
really,
to be
though?
part of a broader attempt to suppress scrutiny of the
Is it really
shareholder
unfounded?
ledger and related records. Defamation per se claims do not need to specify damages. Movement reserves all.
No, but they do need to specify that they're like in order to collect on those damages, you still have to like prove that there's some sort of monetary damage or some sort of thing that needs to be yeah, you can win a per se defamation case without proving damages, but you won't get much in the way of damages if you don't prove that there were damages. Also, calling someone a plant, like, that's not per se defamation, like, as much as you want it to be. This is so silly.
All rights under law to unmask, expose, and if necessary seek legal redress against.
That has nothing to do with the bankruptcy court, so I don't know why you're even bringing it up either.
Against individuals or networks responsible for defaming him, particularly where such conduct may amount to obstruction of justice or witness intimidation. While the personal toll of these attacks is real, the greater harm lies in their apparent intent to delegitimize shareholder oversight and deter future lawful challenges. Amplified messaging such as the plan administrator's dismissive "here we go again" opener or the CONC losery
Yeah.
sanctions demand reflects the same dismissive posture. These rhetorical flourishes do not substitute for legal substance and only reinforce the
Well,
need
that's
for judicial
well, who
oversight.
cares? Because he came with plenty of legal substance afterwards. You're the one that's seeming to fail at the whole legal substance thing.
Oversight. Conclusion. No ledger, no truth.
Is this the new no sell, no sell, no ledger, no truth?
Truth. For the foregoing reasons, Movement respectfully requests that this court enter an order. 1. Compelling the plan administrator to disclose the full shareholder ledger, including the total number of issued and outstanding shares as of the plan's effective date, so that the debtor may exit Chapter 11 with a clean, accurate, and legally supportable capitalization table. 2. Compelling the reconciliation between the shares reported by Seed & Co. and the total shares issued, in order
They're
to
preserve
because
Class 9
integrity.
got liquidated.
Confirm that no Class 9. 15. Case 23-13359 VFP Doc 4150 File June 13, 25 Enter June 13, 25, 13:54 and 19 seconds Desk Main Document Page 16 of 21. Interests were overlooked, overcounted, or inequitably treated in violation of 11 U.S.C. L. 123, A, 4, and 3. Granting such other and further relief as the comp deems just and proper to preserve the integrity of the reorganization process, protect Class 9 stakeholders, and ensure finality rests on TMTH, not omission and fog. Dated June 11, 2025. Respectfully submitted. /S/Jeffrey Meadkerson Jeffrey Meadkerson * P.O. Box 454, Peterborough, New Hampshire, 03458. Peterborough, New Hampshire.
Yeah. So, Like, it's the same silliness. We want a share count. Well, your shares have been deleted, so it doesn't matter. Well, I want a share count. Well, tough shit. The discrepancy is irrelevant because, like, we already know what happened with the shares. So, I'm not sure what he thinks he's going to accomplish there. Not a whole lot. I can almost guarantee it. Let's see here. What do we want to deal with next? So there is the AMC case that I can't remember if I talked about it on any of the previous Truth Be Tolds. I doubt we'll get to it because it's not really like as interesting of a case as I thought it was going to be. I mean, I still find it an interesting case because I like property rights cases. It's just not as, how do I want to put it, as interesting as I thought it was going to be because I thought we were going to be dealing with eminent domain and the takings clause because that's the way AMC sure as fuck sold it. However, it's a little bit more cut and dry. Maybe what I'll do is we can motion dismiss for failure to state a claim on behalf of the city defendants of Grand Island. Ooh, that might actually be better to listen to. So we'll talk about the other two. So there was one of the lawyers from the firm that AMC sued, and basically AMC, well, let's rewind this all the way back. So I'm sure they'll go over it in the filing. But what happened is that AMC had had one of its theaters in a mall. Was it in a Highway 28? Let me see if I can get us a picture of what this place is. Because the mall that they had it in basically was condemned by the city. Woodsonia Highway 281 mall. Let's see if there's a... let me see if we've got like some images of this mall. Ah, yes. So it's an abandoned mall. Here we go. That's going to be about the best picture that we can get of this, I have a feeling. There we go. This mall... Fuck off. No one asked you. Well, so much for that. Anywho. What's this? This, oh, hey, here's the local city. So, yeah, like the city...
But a vote nonetheless, Grand Island City Council will be taking action on a blighted study for major area of town. Woodsonia Acquisitions wants to redevelop around 78 acres, including the Conestoga Mall, with plans to demolish portions of the mall as well as adding apartments. But they do need this designation of blighted land to move forward. If approved, here's what will happen next.
Things up for redevelopment of the mall and allow the developer to bring forward an application for tax increment financing and other tools that the city could use to help them redevelop that property. They're looking at a total investment in this project.
Okay, so yeah, and then we've got this this little image here of what the mall they want to rebuild it as, because look, that's the mall right now, and then they want to kind of, where is it? There we go. This is what they're wanting to try and remodel it as. So yeah, basically, the mall was condemned by the city, was considered a blight, and AMC was like, no, we don't want to leave. We have a lease here. So what happened is the lease owner, the landlord, transferred the lease to the city, and the city told them, get out. And AMC said, we're not getting out. And so AMC did what's, not AMC, but the city did what's called a forcible detainer. It's an eviction, basically. And they evicted AMC out of the mall and kicked them out. And now AMC is suing the landlord because supposedly they think that they can't transfer to the city. And then they're suing the city, I assume, for the takings clause and all that stuff. That was the one I didn't get to read. So maybe there is some takings clause stuff in here. Who knows? Let's take a look and see what they have to say.
In the United States District Court, District of Nebraska, American Multi-Cinema, Inc., Case No. 8:25 CV 292. Plaintiff. V. Brief in support of motion to dismiss or to stay. Woodsonia Highway 281, LLC. Gregory C. Scaglione. City of Grand Island, Nebraska, and Community Redevelopment Authority of the City of Grand Island.
Yep, Grand Island.
Nebraska.
Okay, so we're in the right place.
Introduction. Defendants, the City of Grand Island, the City, and the Community Redevelopment Authority of the City of Grand Island, the CRA, move the court to dismiss the plaintiff's complaint as against said defendants. As will be argued herein, dismissal is appropriate for the following reasons. First, the complaint fails to allege a viable constitutional taking. Second, if a taking is alleged, such claim is precluded by the automatic termination provisions of the plaintiff's lease. Third, in any event, the city should be dismissed because the complaint fails to show any official policy or custom on the part of the city, as distinct from the CRA, could give rise to a takings claim. Alternatively, should the court decide dismissal is inappropriate at this juncture, the city and the CRA request that the action be stayed pending arbitration between the plaintiff and defendant Woodsonia.
That seems reasonable.
Factual allegations. Plaintiff, American Multi-Cinema, Incorporated, AMC, alleges that, through a series of mergers, it became a tenant under a lease for the operation of a movie theater at the Conestoga Mall in Grand Island, Nebraska, the shopping center. Complaint at 11:15. The lease was to run through December 31, 2028. Complaint at 18. In March 2023, defendant, Woodsonia Highway 281, LLC, Woodsonia, acquired the landlord's rights and obligations under all leases for the shopping center, including AMC's lease. Complaint at 20. This case arises from Woodsonia's efforts to terminate AMC's lease and retake possession of the property.
Yep.
AMC's allegations against the city are that, in November 2022, prior to Woodsonia's acquisition of the AMC lease, the city approved and adopted blight studies commissioned by Woodsonia relating to the shopping center. 2. The city approved and adopted a redevelopment plan for the shopping center, and 3. Authorized the execution of a redevelopment contract between Woodsonia, the city, and the CRA. Complaint at 21-25. As against the CRA, Woodsonia alleges that, after Woodsonia acquired AMC's lease in March 2023, the CRA retained Woodsonia's attorney, Gregory Scaglione, to send a letter on behalf of the CRA advising of the CRA's intent to exercise eminent domain powers to take AMC's leasehold interest. Complaint at 35. On the same day, Woodsonia and the CRA executed an agreement entitled Transfer and Termination of AMC Lease dated March 31, 2023, which purported 2. To transfer AMC's leasehold interest in the shopping center to the CRA and to mutually terminate the lease effective as of March 31, 2023. Complaint at 37, EX18. Woodsonia subsequently commenced an action for forcible entry and detainer in the County Court of Hall County, Nebraska, based on its position that the lease had been terminated and AMC wrongfully remained in possession of the premises. Complaint at 47-52. On May 1, 2023, the county court ruled that it would enter an order evicting AMC. Complaint at 52. On May 4, 2023, Woodsonia blocked AMC's access and excluded AMC from the premises. Complaint at 53. Thereafter, Woodsonia began demolition of the shopping center. Complaint at 54. AMC subsequently appealed the county court's eviction ruling, and the appeal was ultimately heard by the Nebraska Supreme Court. Complaint at 5558.
Actually, it's
On March
55 through
14,
58.
2025, the Nebraska Supreme Court issued its opinion. Complaint at 57. The Nebraska Supreme Court did not rule on the merits of the lease termination or eviction. Instead, the Supreme Court held that the county court lacks subject matter jurisdiction in a forcible entry and detainer action to determine whether the lease had been validly terminated. Complaint at 58 to 59. On April 17, 2025, AMC filed this case in federal court against Woodsonia, Scaglione, the city, and the CRA. AMC alleges breach of contract and wrongful eviction against Woodsonia. Complaint at counts I and II. AMC also seeks relief under 42 U.S.C. 1983 as against all defendants. Complaint at count 3. Woodsonia alleges that its constitutional rights under the 5th and 14th 3. Amendment were violated, which prohibit the government from taking private property for public use without just compensation. Complaint at 79. Argument. 1. The complaint fails to state a takings claim because no constitutional taking of property occurred.
Yeah, this is where we're going to get to the argument that all of them made, that basically, since if there was a takings claim violation, it would have had to been against the tenant, because the tenant was the one. I mean, not the tenant, but the landlord, because the tenant doesn't own the property; they just have a lease to it. So that if there was a takings claim violation, it would have to be from the actual holder, which was like what, Woodsonia or whatever, Woodsonia. She's the one who owned the property. Now, if there was any recovery, the recovery can be made for the tenant, that they be given just compensation for having to vacate as a tenant, but that claim would go through the landlord, because they're the one with the actual property rights. And then the fair compensation would be given to AMC through their landlord. But you can't exercise a takings claim if you don't actually own the property. Imagine that.
Threshold issue is whether AMC's allegations set forth a cognizable takings claim. The Supreme Court has recognized two conceptually distinct categories of takings: physical takings and regulatory takings. Tahoe Sierra Preservation Council v. Tahoe Regional Planning Agency, 535.
I'm sure they're going to explain it, but just so you know, physical taking is where you physically take the property. Like, say, for my house, the government comes and says, you don't get to use your house anymore. Or if I want to build something on my land, the government says you can't build anything on the land. That's physical taking. We're taking the thing from you. Regulatory takings is like, if I remember right. Now, I probably should get that property rights in the 21st century video, break that out. Regulatory takings is when, like, say the government requires that your house has to have cable or a phone line to it, or there has to be certain, like, the regulatory things, like you can't have, well, not you can't have, but you must have, like, so say you're building a house and you get it built and the government requires something of you, well, like I said, with the whole, like, cable line, you have to put a cable line. I think one of the ones that was mentioned in that property rights in the 20th century video, it was done by the Cato Institute. It's still up on YouTube, but basically I think the case was that the government in a particular city required that you had to have, like, this cable line come into your house, and Supreme Court ruled, yeah, if you compel someone, a little fucking coax cable even, you make them by regulation have to do this thing, then that constitutes a governmental taking, and you have to compensate them. You give them just compensation for drilling holes in to run a fucking coax cable into their house. That's That's regulatory takings. So, and they talk about Tahoe Sierra and some of the other ones here, but yeah, they're gonna probably go into that a lot better than I just did.
535 US 302 321 2002.1. 1. Arguably, a third category of taking is the exaction taking. C. Dolan v. City of Tigard, 512 US
Nolan,
374, 1994. Exaction takings are not at issue in this case and therefore are not further discussed herein. A physical taking occurs where the government requires a property owner to submit to the physical occupation of
their
that
property,
whether by itself or through a third party. Turntable Fishery and Moorage Corp. B.U.S. 52 Federal CL 256, 262, CT. CL 2002. A regulatory taking occurs when the government prevents the landowner from making a particular use of the property that would otherwise be permissible. ID, see also, United Water Conservation DISTVUS, 133 F.4 TH 1050, Federal CIR. 2025, physical takings are deemed per SE takings that require compensation, whereas regulatory takings are evaluated under a factual inquiry under factors set forth in Penn Central.
Oh, the Penn
Tahoe
Central
Sierra,
task.
at 321 to 22. It is critical to distinguish between the two types of takings because courts draw a bright line between the analysis.
Let's talk. Since we're getting into regulatory takings, I'm gonna go find the video, I guess. Here we go.
Book called.
Let me see here. We should probably have the transcript around here somewhere, even if they didn't do it. Let's find the Penn Central part. No. Control F. Ah, here we are. Is that correct? Come on. Okay, here we are. We're gonna get a small breakdown of the Penn Central test, briefly. Let's switch here. All right.
It's a Penn Central test to analyze whether a regulation is a taking, right? So we have our.
If you want to understand what this whole regulatory taking thing, this is a pretty good video. It's called Private Rights in the 21st Century.
Factors. Our first factor is what's the impact of the regulation, the character of the regulation. I might be getting these wrong. I never remember. And of course, there was the most important one. It was the impact of the regulation on discrete and reasonable investment-backed expectations. Right. Well, they said.
Yeah. Briefly wanted to just deal with that, but let's go back to the case.
Analysis applicable to alleged physical takings and that applicable to regulatory takings. Katzen v. U.S. 900. In this case, AMC attempts to allege a physical taking, to wit, that it was wrongfully evicted from its leased premises resulting in the lost value of its leasehold interest, lost profits, and relocation and rebuilding expenses. However, the complaint shows that there was no physical occupation of the premises by the city or the CRA. Rather, the landlord/developer, Woodsonia, instituted a forcible entry and detainer action and retook possession of the premises
that they own.
The allegations against the CRA are, 1. That its counsel sent a letter threatening eminent domain, and 2. That it executed a legal document purporting to terminate AMC's lease. Such allegations do not allege a plausible takings claim. Mere threats of eminent domain or assertions of legal positions, without physical possession, do not constitute a taking. Katzen, supra, is instructive. The case arose from a boundary dispute between the plaintiffs and the U.S. Fish and Wildlife Service involving parcels of land on the island of Culebra in Puerto Rico. The plaintiffs owned a parcel of property on the island, but the Fish and Wildlife Service also claimed a portion of the property based on a survey and monument markers. In 2006, the plaintiffs signed a purchase agreement to sell their parcel for $4 million. However, the buyer subsequently became concerned about the claim of ownership by the Fish and Wildlife Service. Upon the buyer's inquiry, the Fish and Wildlife Service faxed several documents to the buyer outlining the government's claim of ownership over part of the land, including a survey map. The plaintiffs alleged that the government's claim of ownership caused the buyer to back out of the sale and rendered them unable to sell the property. The plaintiffs 5. claimed that the government's assertion of ownership over the property constituted a taking. The Federal Circuit Court of Appeals rejected the takings claim. The court did not need to resolve the parties' conflicting claims of ownership to decide in the case. Instead, the court held that, even if the plaintiffs could establish they were the owners of the disputed area, the government's mere claim of ownership did not constitute a physical taking that would entitle the plaintiffs to compensation.
Yeah, this is, there's no Platter Amy tonight, Chris, because this is kind of me hot-shotting something. Briefly, we were talking about Jeffrey Kurzon. Now we're talking about AMC is framing it as an eminent domain case, but I'm highly skeptical of it. Game is Advance Wars Dual Strike. It's the only Advance Wars game I haven't played. So I'm kind of doodling while I'm listening to this lawsuit. At some point, I think I've got, after this, we'll probably talk about, I'll probably let our good friend Chris Soika, everyone's favorite neo-Nazi apologist from Shitter, that's an AMC holder, ramble on about how AMC is the greatest investment ever, in between his takes about how, Hitler isn't that bad of a dude, actually. And then we're probably going to call it a night from there.
Internal documents claiming ownership nor the facts sent to the purchaser asserting the claim of ownership constituted a taking.
Okay, so we're going to skip over that.
Kurzon v. United States, a threshold issue in this case is whether a constitutional taking has occurred.
Okay.
As shown by Kurzon, mere assertions of ownership or legal positions, without a physical occupation or dispossession, are not sufficient. See also, Mungall v. City of Pascagoula, 2019 WL 341-3850, ed. Miss 2019, allegation that city sent letter to the plaintiff's tenants claiming the city had acquired the plaintiff's fourplex property failed to state a takings claim. In this case, Woodsonia, as AMC's landlord and owner of the fee estate, took the position that the lease had been terminated based on the transfer and termination agreement. Woodsonia threatened eviction based on termination of the lease and ultimately sought to evict AMC based on the termination of the lease. The premise of AMC's lawsuit is that the termination was ineffective, and the eviction was therefore unlawful. Complaint at 82.h. Notwithstanding such conflicting legal positions, there is no allegation that the CRA or the city dispossessed AMC of its physical occupancy of the premises. The complaint makes clear that Woodsonia served the 3-day notice to quit and prosecuted the action to evict AMC.
That is going to be the key argument here, that basically it doesn't count as a taking under the takings clause because the lease was owned by the leaseholder. Not the leaseholder. The lease was the landlord. And so the landlord evicted you, not the city. Therefore, you get no takings clause. Have a nice day.
AMC. Complaint at 47. The case.
And of course, the one that I had read that was before this was basically their landlord saying that since the city condemned the property and basically said that it was blight and we're gonna bulldoze it so we can put in a new mall or whatever shopping center they're going to do, that since it's in our actual agreement here that if the city determines that the property is a blight, we get to terminate the lease. It's in the contract. So basically what's going on here is, and the third thing also that they were fighting over is that AMC wanted, I think, compensation for lost revenue, and I think they're like under Nebraska, well, under most state law, but they said under Nebraska law, which is important here because this is in Nebraska, that that basically that's not allowed because like imagine trying to calculate what lost revenue is. It's such a, there's so many inputs that go into it. You could come up with many different ways to calculate what sort of lost revenue for the period time. So, you know, you just get fair value of what the actual leasing contract would be worth if you sold it. You don't get to calculate lost revenue or anything like that because it's too fudgeable. Like there's too many factors that go into it. We can't get an honest, accurate number. So yeah, that's basically what AMC is fighting over. And also, an argument that one of the defendants made, I think the landlord, was that AMC is basically trying to get around the fact that there's an arbitration clause in the contract. So they're also asking for a stay to force AMC into arbitration, which I'm pretty sure they'll get. This just seems like more legal shenanigans from AMC. When Tony De Niro is even like, why are they fighting over this? Just what are you doing? You have so many other theaters. Why are you fighting over this one theater in fucking Grand Island, Nebraska? Like, who fucking cares? But apparently AMC cares, so here we are in Nebraska federal court arguing over a blighted mall theater.
Case was litigated.
I don't get it.
7. Nebraska Supreme Court with Woodsonia as the named plaintiff. C. Woodsonia HYWY 281 v. American Multi-Cinema, Inc., 318 Nebraska 592, 2025. Neither the CRA nor the city were parties to the action, and there is no allegation that they were responsible for the physical dispossession of the premises or that they subsequently occupied the premises. AMC's complaint fails to allege
you know, if I was AMC, I'll play for the plaintiff there, I would say, well, there's no allegation. I don't know about that. That seems disingenuous to AMC's arguments. But, like, the reason they were dispossessed of the property was because of the city. The city declared the mall and the theater in the mall blighted and that it was going to be bulldozed. So, yeah, and it was kind of the city's fault to a certain extent. Does that mean that it's a takings? I don't know if that's the case legally, but, I mean...
Physical taking by the CRA or the city.
But yeah, it definitely wasn't a physical taking. Maybe a regulatory taking. In which case, enjoy your time in Penn Central hell.
Or took possession of the premises. At best, the CRA threatened eminent domain and executed a document establishing a legal position that the lease was terminated, but it was not ultimately responsible for AMC's loss of physical occupancy. As in Katzin, even if AMC is ultimately correct that the termination of the lease was invalid, AMC does not have a takings claim because the government never dispossessed AMC of its property.
Oh, that's what they're going to go with.
And the CRA's assertion of a legal position do
that
not
works, I
constitute
suppose,
a physical taking.
Yeah, because
Two,
we didn't
the
physically
plaintiff
take
fails
it,
to
bro.
state a claim because the lease's automatic termination.
We didn't take it from you, bro. We didn't take it. Your landlord took it under the terms of your contract. So how could it be a taking? We didn't take the thing. AMC shouldn't have gone with the physical taking. I think maybe he's saying it's a regulatory taking. You blighted the property, therefore it triggered the clause in the contract. But I'm not a lawyer, so maybe that's also dumb.
Termination provisions are valid. Assuming the allegations of the complaint state a viable takings claim, such a claim would be precluded by the automatic termination provisions of the lease.
Yep.
Where a lease
Which I
includes
just
a
got done
provision
talking
for
about earlier.
automatic termination upon the taking of property for public use by a governmental authority, the tenant has no right which persists beyond the taking and can be entitled to nothing. U.S. v. Petty. 8.
Oh, well, there you go.
Motor Co. 300 and
See, I didn't even know that. So there goes my dumb idea of regulatory takings. Way to go, city. Pointing out that where the government authority triggers an automatic provision with the tenant, it's not a taking. Eat a bag of dicks. Good to know. I have to click it.
327 US 372, 376, 1946. See also, Badgeway v. Sunoco Incorporated, 320 F. Sub.2 D 454, ED Virginia 2004, Utah Department of Transaction v. Kmart Corp., 428 P.3 D 1118, Utah 2018, Fiberglass Fabricators Incorporated v. Kolbig, 799 P.2 D 371, Colorado 1990, collecting cases and authorities. In such case, it is the tenant's contract with its landlord, not the condemnation, that terminates the lease.
Yep.
USV. Right to use and occupy 3.8
That's,
acres of land, 484 F.2
good to know
D
distinction.
1140, 1144, 1973. In USV Petty, Supra, the federal government had temporarily taken over a leased building. The government arranged with the property owner to pay compensation for the temporary use of the building, but some of the building's tenants disputed the compensation offered to them. Pertinent here, the Supreme Court noted that the lease of one of the tenants included an automatic termination provision. The court stated, "We are dealing here with a clause for automatic termination of the lease on a taking of property for public use by governmental authority. With this type of clause, at least in the absence of a contrary state rule, the tenant has no right which persists beyond the taking and can be entitled to nothing." 327 US at 376. Thus, the tenant did not have any claim for compensation for loss of the leasehold interest. In this case, AMC's lease included a provision for automatic termination of the lease if the premises were taken by eminent domain or under threat of eminent. 9. Domain. Complaint at X. A. 15.1. Moreover, any condemnation award belongs to the landlord. Complaint at X.
Yep.
A. 15.2.2. 2. The lease reserves to AMC a claim against the condemner for interruption or damage to AMC's business, and on account of any cost or loss AMC might incur in removing merchandise, furniture, or other personal property. Complaint at X. A. 15.2. However, as explained above, lost profit and relocation costs are not
Aren't one of
compensable
them.
damages in a federal takings claim under the Fifth Amendment of the
Yep.
U.S. Constitution. U.S. v. Petty, 327 U.S. 372, 377-78, 1946, evidence of loss of profits, damages to goodwill, the expense of relocation and other such consequential losses are refused in federal condemnation proceedings. See also, Land Use
'Cause they're
Planning and
complicated.
Development Regulation Law 1615, Non-Compensable Damages, 3D. Ed 2024 Update. AMC alleges a taking has occurred. Accepting this allegation as true, the lease is terminated according to its own terms and there is nothing left for which AMC can be compensated. Put simply, if a
Yeah.
taking has occurred, then the automatic termination provision applies and AMC is not entitled to compensation. On the other hand, if there is not a taking, then the city and the CRA cannot be liable. To thread this needle, AMC alleges that the automatic termination provision only applies when the fee interest in the premises is taken. Complaint at 75.
What?
But there is no support for such position in either the language of the agreement or the case law. The lease itself does not require a fee taking before the eminent domain provisions found in Article 15 apply.
Yeah.
The provisions refer to the demised premises, which is the tenant's lease
Oh
space.
no.
Complaint
You
at
killed
X.
my infantry. That's
A.
not nice.
15.1. The lease further states that any condemnation award for the value of the leasehold estate shall be paid to the landlord, and that the landlord may transfer the demised premises or any portion thereof to the condemner free from the lease and the rights of the tenant. Complaint at X. A. 15.2 and 15.5. There is nothing in this language indicating that the condemner must take a fee interest in the real estate before the eminent domain provisions apply. To the contrary, they reflect an 10. Intention that the landlord may convey the demised premises, including leasehold interest and / or any portion of the premises, to the condemner under threat of eminent domain. This is notably consistent with Petty. In Petty, the tenant's lease contained a nearly identical automatic termination provision that referred to the demised premises. The provision was applicable when the government sought temporary use and occupancy of the building, not a fee taking. In sum, AMC's allegations fail to state a claim because the claim is precluded as a matter of law by the automatic termination provision of the lease. 3. The City of Grand Island should be dismissed from the action because the complaint fails to allege any facts showing a taking by the city.
Sounds about right.
Assuming the complaint alleges a plausible taking and the claim is not precluded by the lease provisions, the city should be dismissed because the complaint fails to allege any official policy or custom adopted by the city that violated AMC's constitutional rights. It is well settled that a municipality cannot be held liable under 1983 based on a theory of respondeat superior, meaning it cannot be held liable based solely upon the acts of its employees or agents. Monell v. Department of Social Services, 436 U.S. 658.
Oh, this was what was mentioned. Okay, so that got I get it now. So that lawyer that AMC is suing was a lawyer for the city, who was transferring information. He was acting as an independent entity and that. So okay, this is getting back to that a municipality can't be held based on the theory of respondeat superior, meaning it cannot be held liable solely upon the act of its employees or agents. It must show that the official municipal policy of some nature caused the act.
1978. Instead, the plaintiff must show that an official municipal policy of some nature caused a constitutional tort. ID. As stated in Monell,
Ethan might want to hear that.
A local
one.
government may not be sued under 1983 for an injury inflicted solely by its employees or agents. Instead, it is when 11. Execution of a government's policy or custom, whether made by its lawmakers or by those whose edicts or acts may fairly be said to represent official policy, inflicts the injury that the government as an entity is responsible under 1983. ID at 694. As shown in the complaint and attachments, the city's role was limited to adopting resolutions to approve the redevelopment plan and redevelopment contract for the shopping center. Complaint at 24. The complaint does not allege any further action on the part of the city. Passing blight or redevelopment ordinances does not rise to the level of a constitutional taking. See Skun v. Olson, 427 F sub 724, ed. Wisconsin 1977. City's proposal to redevelop blighted downtown area was not a taking in either the legal or constitutional sense. See also Danforth v. U.S., 308 U.S. 271, 286, 1939. The mere enactment of legislation which authorizes condemnation of property cannot be a taking. Instead, the takings allegations are directed at acts allegedly committed by the CRA. The allegations are stated in paragraph 82. All of the allegations relate to the CRA, rather than the city.
Oh wow, I
CRA
managed to get an
is
S
a public
rank,
body
even
with
though I
its
did
own
pretty
power
shitty
of
there.
eminent domain. Nebraska Reverend STAT 18,2107
I'll
and
take
18
it.
to 2122. There are no factual allegations to support a takings claim against the city. The city should the court determine dismissal is inappropriate at this juncture, the action should be stayed pending arbitration.
Yeah, it should be stayed pending arbitration and yada yada yada. Yeah, I really don't see AMC winning that. I don't see anything good there for them that's really going to help them in any way. So what we're going to do see here. Let's see if we can make this. No, that's not what I wanted. Thanks for doing that. We're going to switch things up here. So we're going to close this, change that. Yes. What we're going to do is that. Then what we're going to do is bring our good bigoted friend over here. Find a way to like. There's a better way to center him. Oh well. We'll just go away. We'll just, I guess, have to live with that. Then I don't know, we'll just roll with that, I think. Let's see what Soika's been up to with his little starter jacket there, straight out of Eastern Europe. Let's see if we'll be able to actually read the dry board this time. That'll be a real game changer if we can actually read that. Uh-oh. Uh-oh, one of his markers died. Man down. Man down. See if I can find something here to fill in this gap over here.
Oh.
Well, things were not very pretty in after hours, I see. Yeah, we'll fill it in with
Run on,
that.
everybody, like and share, and we'll get started right away.
Yeah.
Interesting tweet coming out of Elon Musk talking about Donald Trump being on the Epstein files. It is.
Oh yeah, I forgot. This was back like before all that resolved itself. So this is like, I want to say Sunday is when this video dropped that he did. So yeah. Wonder how he's handling that one.
But when he did not release the Epstein files and Pam Bondi didn't release the Epstein files on day one, it should have been pretty obvious that they was compromised. We've been saying this in our feed, on our Twitter, for over a year now, that the American government is compromised.
Yeah, let's talk about Chris Soika and that compromised stuff. Oh fuck it, we're gonna full screen this. This dude is quite possibly the worst. He's up there with little Michael. On the speed run for being Nazi apologists here. Of course, 10,000% sure that they lied to us about Hitler. Cool story. Also, this is a guy who loves doing knob polishing for fucking Andrew Tate. Oh yeah, I forgot he's a Nick Fuentes boy too. Of course, check all of those boxes. Why don't you? I think I found who's really compromised here. Oh, here we go. So, the first thing you... I forgot about that one. Oh my god. Yeah, that was there too. We live in a world where this symbol is more controversial than celebrities fucking children. First of all, why does there need to, like, false equivalency here that there needs to be any sort of, like, conflict? I can hate both. But number two, the systematic murder of millions of people isn't a bad thing in your mind? also, all you need to know about Soika, if you spend any time looking at his feed, is that he's a Christian nationalist. And so he has a real hate boner for both Jews and Muslims, and thinks that we should have a theocracy, a Christian theocracy that rules this nation, because, yeah, it totally, the First Amendment, that separation of church and state, that was just in there as a joke. That's not a real thing. Come on, guys. You want a theocracy, don't you? Fuck off.
They fell victim to a honeypot operation on Epstein Island. They're compromised by Mossad and the Israeli government. And
We were just talking about, and not but 5 seconds later, this dude's like, the Jews and Mossad and da 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 da. Oh my goodness, he's you can't make this shit up. He is just like a caricature of what a neo-Nazi is.
You did not have a president. You did not have a president. President Biden wasn't your president. The auto pen was. And who controls the auto pen? Most likely the people who control Israel and who control the freaking people in power.
It's the Israelis. They're so fucking evil.
Power in the United States
So fucking evil.
Because they got into honeypot operations and they're being blackmailed. So in order,
I really don't need to know about
blackmail
that,
from
but thank
coming
you.
out, yeah, they arrested Jeffrey Epstein and someone tipped it off, and they killed Epstein because of it. But Ghislaine Maxwell hasn't named any names. There's nobody on the list. So the reason why you're seeing all this pro censorship from Israel and Jewish people in the United States is because Israel has compromised its position in the United States with the Jeffrey Epstein files, and they've lost their power and control over the United States.
I just came here to listen to you blabber on like an idiot about AMC. What the fuck is all this shit?
The people is lost in the government. Israel loses its power to control the people because we don't believe what the government has to say. And we haven't believed what the government has to say.
He's still fucking going. Where are you, Manuel? You're missing the good stuff. Oh my god.
These are proxy people in the United
What
States.
in the world?
Everything in the United States that control Harvard University, Yale University.
I'm so
they're
confused.
the headmasters of all our institutions. They lead all of our technology companies. They control all of our media companies. And they're freaking controlling our.
He is still going.
So there is literally no way to break from Israeli control other than to have people wake up to it. Okay. And,
Oh my
first of all,
goodness.
while Israel was stupid enough, they could have just controlled the United States.
You gotta get to
forever.
AMC
Instead,
sometime,
they wanted to
dipshit.
pick people off and go and commit genocide in Israel.
Oh my
And that
goodness.
made people really dig into.
Yeah, I know what a
why,
cruiser is. Thank you.
Basically, Jewish people have so much power to commit genocide, and why they get the backing of the United States while they commit genocide. And they're able to commit genocide in Gaza because they have blackmail
Whoops.
on the United States. And if they don't let Israel commit genocide, then they'll expose the people in the United States. And if they don't keep giving them money, they'll expose the people in the United States. It's all a honeypot operation. But how does this play into AMC? These are
Nothing. It has
multi-front
nothing to
wars,
do with AMC.
And
You're
right
just
now,
a bigoted
AMC
piece of shit.
AMC is the one company in the United States that's owned by retail investors. And how you fight back
No.
against this system of power and control
It isn't.
is you get a vehicle to success that beats them at their own game. Now, they can shut down the global markets, but it's only going to wake people up faster. It's only going to create more awareness around the situation. It's going to make people notice more and more that people are in control. If they do a COVID 2.0, it's going to make people understand that someone's pulling the strings. This isn't a once in a 100-year thing. This is a once in every 5 years thing. People
What
are
again
creating
is AMC
viruses
trading at
and
right
spreading them
now?
amongst the people,
What?
and then
What?
making people-
No, you shut up. Like, you shut up. Let's pull up Weeble. What is AMC trading at right now? Think. Oh, there we go. What is AMC trading at right now? No, that's not what I wanted to move. This. Thank you. Let's play a little game, Chris Soika. No, I'll do updates later, but thank you for that. Oh, wow. $3. Oh, yeah, it's really shaking up the world markets right now. Oh, yeah, it's definitely the things that that cannot be controlled. You had that big rise up for AMC earnings, and it came straight back down because AMC is still a fucking piece of shit shitco. Oh, whoopsies. I think I accidentally clicked on the weekly button. Whoops. What happened here? Oh, boy. Anyway.
People sick and then giving you a cure and then fucking with the markets and fucking with the workplace and fucking with
No, the only thing that, like, there's no one fucking with the markets. You picked an insolvent shitco, dude. Get over it. You were an idiot and you lost. You lost big time by being a big fucking idiot. That's the only thing that happened here. Like I was a big fucking idiot by letting my cruiser drift into rocket range there like a big dumb numpty. At least it's out of battleship range. Yep. That's my fault. I don't blame Nintendo manipulating my gameplay or, you know, restream fucking with my gameplay. No, I made a dumpty I made a numpty mistake. And so, well, yeah. So take responsibility for stupid fucking actions,
that
dude.
shouldn't be, right? So everyone's starting to become aware, and a lot more people are starting to notice how much power these people have over the United States of America and its politicians.
What?
And Elon just exposed it on X by saying, hey, Donald Trump is in the Epstein file.
Yeah, I wonder how embarrassing that is for you right now that he backpedaled all of that because he got made to look like a clown. Because he figured out that, you know, after all these years that, you know, he can bully everyone but the cult leader. Whoopsies.
Well, that shouldn't be a shocker to anyone because they weren't released on day one. It should be just, hey, here's a list of the people that were on it. Every single one of you should go to prison. It should be that simple. But the problem is that he's on the list. People and prominent members of the government
And
are
you
on the
voted
list.
for him.
Mark
Slick.
Carney is on the list. Keir Starmer is on
Like,
the list. People from
do you think we're
France are on
confused by the
list.
fact that
world politicians who are
you didn't vote
flooding
for Donald
their
Trump?
governments with illegal immigrants are there
No,
because
we're not that fucking
Israel's
stupid.
plan to destabilize the West and ultimately
Jesus Christ.
flood us with immigrants and refugees from the
See what I fucking mean? Like, you voted for this dude. You're a fucking clown. At what point are you going to start actually talking about AMC instead of this numpty nonsense,
the Middle
please?
East, which is Israel ultimately. So, in case you guys don't know anything about politics,
Still mumbling about Israel in the background.
This is
Jesus fucking
we're fighting on
Christ.
different fronts here. Okay, we're fighting a multi-front war. We're fighting a political war. We're fighting a financial war. We're fighting a spiritual war. Okay. And these
That's
hedge funds
spiritual
are
war
fighting
too.
money.
Okay.
The hedge
Sure.
funds, the banking
Cool
system,
story, bro.
the market makers. Okay.
Tell us more about it, I guess,
They're
since
all
you're not going to talk about
backing
AMC.
These guys are giving these guys money, and they're trying to get as much money as they can. Super low interest rates for their friends at the hedge funds, trying to.
Your bro, the dude bro in the administration's the one that wants lower interest rates, for the record. I bet he thinks that lower interest rates means inflation because he's a numpty fucking idiot. Oh my goodness.
Make it so that they can make money. These market makers are fixing the prices, and AMC is getting absolutely pummeled in their stock price, incapable of raising capital. But what happens? We just get an army of apes. We get our army of apes, right? And we fight them off by going to AMC theaters and spending money. Okay? And people are like, well, how does that work, Chris? Well, it's pretty simple. you know, they're short something, which means that if it has to pay out, they owe you something. That's what being short is. It means to owe something. So they're short AMC, they owe AMC. They owe it to the system to buy it back eventually. And if that company starts to make money, they owe money to the people that they sold it to.
No, they just own the shares. The difference is the price of those shares. How do you fuck up explaining how short selling works so epically? You've been doing this for 4 years and you're still the biggest idiot I know.
That they also owe shares to, okay? Because they have to locate those shares that they sold short. So the army of apes goes to AMC, they drive up the money, they pay off the debt, they get all this stuff. And the hedge funds, the banks, and the market makers say, you know what, we'll just crush the stock, we won't let these guys do anything. Adam Aaron, you know, hopefully not
goodness.
on Epstein Island.
I forgot how painful this guy is to watch sometimes. Not even, well, I mean all the time. Like 10 minutes, not even 10 minutes in, and he's already.
And he gets gold and silver, right? Boom. You're not really gonna be able to see that. That says gold and silver. Okay. I know it's yellow. I don't give a fuck.
Oh, whoopsies.
I don't think that
Didn't
makes it
land
better.
quite where I should have. Whoopsies.
Well, it is what it is, my friend. Gold and silver. Okay. Got gold and silver HYMC. Okay. This is.
I think we can actually
not
read what's on his
alignment
dry
against
erase
these
board for
people,
once. He's
okay?
figured out how to
You
get
have
that to work.
alignment against these people.
Amazing.
Now, you have HYMC and AMC as stocks, but
Oh my goodness, he's going to
You
talk about
also have
HOAMC, the
gold
the
and
company
silver
that's already gone bankrupt
now
once, trying to mine the
stackers
same mine,
who are
and also,
unbeknownst
by the way,
themselves,
is diluting
your friends,
again.
right? They don't know that you're friends with the gold and silver stackers, and the gold and silver stackers don't know that you're also part of their movement, because they want real money and these guys want fake money, and you guys want real shares and these guys want fake shares, and they want fake money, they want fake shares, and they want fake success, and they want fake reality so that they can sell
What?
you shit reality. They live in the fantasy world because they created the fiat currency, they printed the fiat currency, they printed the fake shares, they're on borrowed everything, and they're borrowing basically your time in life.
I love getting explained
But
economics
where this
by a
gets out of hand is
5-year-old.
They print too much money, and gold and silver start to.
They print too much money. Are you sure about that, bro?
Rise, right? And the gold and silver stackers will not sell real physical gold and silver until they see prices that they see fit, right? So these guys start a war with the guys that you're fighting, and these guys are like, wait a minute, how did AMC join the gold and silver movement? Well, they bought the biggest gold and silver mine in the United States.
Not the biggest gold and silver mine in the United States. Let me look that up, by the way. Okay, first of all, the Carlene mine is the biggest gold mine there, dipshit. And it's going to operate for at least another 7 years. I don't see Highcroft in there on that list any fucking where. Okay. About silver. Yeah, again, silver mines. I'm not seeing Highcroft in there any fucking where. That looks like it. In fact, it's not even Nevada. It's fucking Alaska. This dude can't help but lie. It's like it's woven into his stupid fucking DNA.
And they went on the attack with gold and silver from a different direction. So now they're attacking from AMC, they're attacking from HYMC,
and they're attacking.
He's also got to pretend like he's part of this faux revolution that doesn't actually exist. Amazing.
As it goes up or down, it hurts or helps hedge funds in their leverage situation. But all of this is now tied to real money, right? And Adam was a genius and able to tie his war to real money. So no matter how much they print, real money becomes their enemy, okay? Every time they print dollars for themselves, they hurt themselves because gold and silver have to go up. It makes it an even more rare precious metal, and it makes it harder to locate, and it makes it harder for all the things that
It's
they
funny
own to
all these
actually become,
stupid fucking narratives he needs to come
real,
up with
right?
to try and sell
they
you
own all
on
the technology
an
companies, they
insolvent
own the
theater
artificial
company.
intelligence companies, they own Apple,
Amazing.
and Netflix, and all these things, but all those things depend, and their infrastructure depends very much on graphics processors and technology and databases and all these things and credit card processing data centers and all these technologies that take gold and silver to keep updating. So, and real money to keep updating. So if they can't print the money to get the labor, they have to go get it from real money and real successful businesses, okay? And their businesses are gonna get shut down because they're gonna start paying higher prices for gold and silver.
If they have a company that makes money, it's solvent, and has earnings, why would they need to shut down? Like, biggest doofy fucking idiot. Like, imagine thinking that you're so, like, this isn't even midwit, because I'm not sure he has even the IQ score to claim midwit status. This is just idiot.
Some of those businesses that are dependent on that gold and silver staying at that price aren't going to be able to compete. They're going to price consumers out of the market. Now, how does the army of apes fight back? This is how we fight back. We go to AMC, we buy popcorn, drinks, we go to chocolate, we get everyone involved, we A-list America, we do all those amazing things. We start fighting like fucking hell with these people, okay? You know, the Vanguards, the BlackRocks, the State Streets, all these people who have basically enslaved the American people in their little their little fake money printing scheme, right? Because once we were disenfranchised from our money printer and the Fed started printing money, they were just going to print the power.
The Fed doesn't print money, jackass.
Power, they printed the power to themselves. They just said, hey, we'll give you 10 cents for every dollar we give ourselves. And people said, oh, thank you. I could really do with the 10 cents. But now the 10 cents doesn't buy you a loaf of bread. The 10 cents doesn't buy you a gallon of gas. The 10 cents doesn't buy you a cheeseburger at McDonald's. The 10 cents doesn't buy you shit. 10 cents is basically, you know, a tenth of a penny at this point. They've devalued your currency, and they've devalued your labor, and they've devalued everything. So now the way to take it back is to buy one company, which is really, really successful, which is really, really
It really, really isn't,
a lot
though.
of money, right? Make it a great investment vehicle. Pile into that company collectively as a working class.
So you can
people
pump his bags and
fight
he'll
back
stop
for
being
your
a
country,
poor ass
okay?
baggie.
Now, you take this company and you make it successful, and you start getting paid, right, to be an AMC shareholder, and then you can take that and spread that into other businesses that you deem successful, and you can start to take back your market. You can't take back your market until there is some transfer of wealth from these people to these people, okay? These people have to yield
But you
something to
can.
the army.
You can make money. You just don't pick shitty companies like AMC. You invest in stuff like, oh, I don't know, you can like just basically owning the S&P 500, VU. Like, you already have beat this numbskull. I don't even.
Apes, and it can be a never-ending process where we just continue to win because we own the greatest investment vehicle of the 21st century, which is movie theaters. Yes, entertainment, we own it, we're the best. We're the most movie theaters in the United States. It's going to be a multi-billion-dollar a year business. Popcorn and drinks, all the best screens. And people say, well, it's not that good of a business. I've checked our balance sheet. You just don't understand balance sheets.
Oh, I do understand balance sheets. Would you like me to get AMC's balance sheet for you? It's a fucking disaster. Let's go get get AMC's balance sheet so we can, in real time, look at how much Chris Soika doesn't know shit about finance. Where are we? Here we are at Cap Edge. AMC. Financials. Balance sheet. Rip. Alright. Do tell us more, Chris, about what we don't know about balance sheets. One sec.
You need to read balance sheets, you need to understand balance sheets, you need to see
Uh-huh.
revenue streams, you need to see growing revenue streams, you need to see new trends popping up, you need to research things like a Paramount decree. There's a whole bunch of things that you're missing probably if you're watching this video and you don't know what the fuck I'm talking about. First thing.
Well, I don't know what the fuck you're talking about because it doesn't have anything to fucking do with balance sheets. He knows that talking about AMC's shitty fucking balance sheet is his fucking kryptonite. And so he does a bunch of fucking bullshit to not have to talk about it. Earth to dipshit, you have the same amount of shareholder equity as you did in 2021. You've been on a treadmill for 4 fucking years. Let's go by quarter. Yeah, 1.74. That was your last earnings. What was it in 2021? 1.79. Wow. You successfully got $50 million more dollars. Well, not even that. Yeah. $30 million more dollars of shareholder equity. Congratulations. You're still swimming in fucking red ink. This company is still at threat of going bankrupt. That's why it had to do that big, stupid refinancing. It currently has only $378 million worth of cash left. And if you go to the income statement, funny enough, that gives it a runway for another quarter and a half. You're fucked. Unless they do something different. You are fucked. Luckily, this quarter's been good, so maybe you won't have that burn rate problem. Maybe you'll break even, but like, without buying another quarter at least, before they have to do another reverse split probably and start diluting more shares. There's a reason why Chris Soika is fucking afraid to, like, he comes up with all this numpty nonsense anytime he has to talk about AMC's balance sheet. Because it's fucking embarrassing. He can't talk around it.
First, start off with the Paramount decree, study its history. Right there, if you didn't know that existed, that's
It's
your
irrelevant.
The second problem is new revenue
Second problem is you don't know fucking anything about finance.
streams and debt reduction. Follow new revenue streams, chocolate, popcorn in retail stores, and then go and look at what's the word I'm looking for? Debt reduction. See how much AMC has paid over the last 4 years.
It's not done anything. Like, we saw that your shareholder equity's flat. It is flat as a monkey's ass across the board. But let's go bring that back up. Let's bring it back up since he wants to talk about their debt payments. Let's see here. What about your debt payments? Current debt. Your current debt's actually gone up. So that's short-term debt. That's your non-current debt. It's gone down since 2020, since 2021. You still have $4 billion worth of debt. Oops, that's the income statement. And since good old Adam, yeah, 4.13. Since good old Adam decided to kick the can down the road, your interest expenses have actually gone back up because he had to refi. And of course, they're not going to refi into a company that's struggling for a lower interest rate, especially with interest rates being higher. So, like, what did you gain? Like, you're still in the same place you were 4 years ago. An over-leveraged theater company that, if things don't get better, is super fucked. Super fucked.
Just during COVID, during the strikes, it was able to pay off about $3 billion worth of debt. Okay? What do you think
still
this
have
company's gonna be able to
you
do
still have $4 billion
when they're
worth of
successful?
debt.
When the movies come back, and they have come roaring back.
Have they though? Have they though? Because we're still not back to pre-COVID levels as far as theater things were concerned. And if you remember the last discussions that I had with Tony De Niro before my original channel got shit canned, he was Adam Aaron was talking about 2025. This was going to be the good year. Still not back to 2020 levels. Like pre-COVID, 2019. Still not back to those levels. Roaring back. This is the tactics of a snake oil salesman.
When we see a record 2026, a record 2027. What do you
Sure
think
about
is gonna
that?
happen? Okay? And all of this is going to unlock the things in the Paramount Decree while simultaneously locking in
What
the
even
fact
is this
that
stupid
these
fucking
things are-
Paramount Decree
we
that
are
he's talking
fighting
about?
them on multiple fronts from
Does
multiple
anyone
angles,
know?
and they're not able to
'Cause I
contain the
sure don't.
situation. If they print money, they get gold and silver to skyrocket. If they don't
Let me
print
guess,
money,
this is a fog
right?
of war map.
If they don't print
Hey,
money,
there you go.
we just have to make this successful and drain them of their money. Their money, right? Their money, once we create a dividend here, it just starts going down because their money starts to go like this and that to us. That goes to the ace. Money starts being transferred the second the dividend is issued. It doesn't matter if the stock is at 4 or 50 or 500. No wealth has
Screwed that up. I
transferred
should have gone with the infantry
until
first.
you either sell the stock
Jeez,
for a
we'll just
gain
redo this.
or a dividend is issued. And they don't want to run the stock.
They're not going to issue
They want to
dividend.
wait you out. They
Newsflash.
want to be patient. They want to fight you with time. So your key here is to accelerate the rate at which you get the dividend paid so you can start the process of draining them of capital. Okay? Which would put them in a position where they would have to either print money, driving the price of gold and silver up, driving the value of gold and silver up over here at HYMC Mine, which is doing some extraordinary work on its studies. 30-something million ounces of silver, 12 million ounces of gold. You know, biggest silver mine in North America, biggest silver resource in North America, and adding second largest gold resource in the United States, and it's probably gonna be.
I like how he's gone from it's the biggest mine to resource. Like, he just makes shit up as he goes.
That very soon. So they're probably number one in that. But we own this, and if they print that money, our gold and silver mine is gonna spike in price. And once we start mining it, it's gonna be explosive. We're gonna get tons of money. There's probably gonna be dividends there. Which again is going to pay into the army of apes, which is going to leverage itself into buying more things at AMC, owning more AMC stock, creating a dividend over here, and pushing more money into AMC. We are attacking them on multiple fronts, but we have yet to get to the
We're
point
attacking them
where
in
we
this
can attack
mythical
them through
war
the
that
dividend,
he's
which is
made
the
up in his own
ultimate
stupid
nuke
fucking
on
head.
their balance sheets. They
Yeehaw.
must represent a taxable event where, hey, I'm paying these people money for something, and they're claiming it on their taxes. AMC shareholders are claiming, hey, I own these shares and I have to pay taxes on these shares. You're paying me for those shares. You have to represent yourself in that tax form saying you paid me. Otherwise, you can't claim it. You can't claim a loss that you didn't take. And they're going to take losses. And how are they going to take billions of dollars in losses if, there's only 400?
If they don't realize them, or hey, how about the fact that the company is trading $3 a share? Most of the shorts have already left. All the ones that were shorting from the top down have for sure left. Like this
100 million
dude
shares.
is in fucking fantasy la la land over here.
It's an accounting problem here.
It
And
really
it puts them
is.
in a situation where their accounting doesn't line up. It exposes the naked short situation. And whether they want to fucking have the IRS or the DOJ
Making
or the
shorts on the bingo
FBI
card.
or the CIA or the NSA or any of these three-letter dickhead agencies who do absolutely jack shit for the American people step in and start doing something, it doesn't matter because they owe us. They owe us money. And this is going to go to court and you're going to sue.
Question. It's gonna go to court. If the three-letter organizations aren't doing anything for you, why do you think that the federal government in any aspect or any court has to do anything for you? If you think this conspiracy controls the entirety of the government, why would a court pay you anything or think that you were owed or obligated anything? Like, the fact that this all-encompassing, everyone's involved conspiracy, that they don't think that also that might include these people, this, like, might just absolutely destroy their narrative, because it just might include also the courts and all these other things. Nah, like, they have to pay us. Because otherwise my stupid fucking narrative falls apart. Oh, well, that's a real great reason.
Sue them for securities fraud if you don't get your money.
Big if true.
Now, all of this, and today, I mean, like, you may have seen the start of a civil war in the United States. I mean, you basically know that your president is fucking, you know, was on an island doing some weird shit, whether that was with prostitutes or kids or sex slaves.
I'd like
and
to
you
know
that the
who
Democratic
this
Party
guy
didn't want to
thinks is
reveal
going
that
to, like...
information. So they were there, the Republicans were there, so the elite had one big fuckfest party on Epstein Island, and they're getting exposed by Israel. So Elon Musk dropping this bomb on the world really just lets you know that the elite in America are compromised. None of them are trustworthy. The government isn't trustworthy. We don't know who's in charge. We don't know who's
If the
giving
government
Trump
isn't
Trump
trustworthy,
orders.
then
We didn't know
why
who was giving Biden
would you
orders.
trust
We don't
them
know anything anymore. There
to
is zero. If you
give
have
you
any
your
trust in the government
supposed
at this
payout,
point,
your
you have
mythical
basically
fucking
lost your
payout.
fucking mind. It is one gigantic shit show. If you believe the Democrats were good people when they were doing the auto pen shit, you're basically brain dead. Like, don't talk to me about politics ever again. Don't call me about politics. Don't text me.
Oh,
An
good. I didn't
auto
ask
pen
for your
from a
unsolicited
fucking,
opinion
you know,
on your
brain
stupid
dead
fucking
president is
politics.
literally signing
You
pardons for
neo-Nazi
criminals who
fuckwit.
embezzled money from the United States, and you're trying to
Please
protect
keep
that
them
party
to
and flag
yourself.
that party. On the other hand, you've now got fucking the president of the United States implicated in fucking sex crimes on a fucking honeypot
According
operation
to
in the fucking Bahamas, controlled by
guy
fucking Assad
who
and
is
Israel.
high on all
And
sorts
the
of
Republicans
substances
basically covered
and
for that
was
as well,
wanting to
and
get
haven't
back
done
at
anything.
him
So both parties are
because he
guilty as
didn't,
fuck.
like,
Neither of them are trustworthy,
how he threw
and
him
it
under
would
the
look
bus.
like they are all part of the same operation of covering for each other's tracks and letting people into their elite status and protecting their elite status at all costs by passing massive bills to pay themselves through non-government organizations. They have fucked the United States.
Imagine being
But
such a
guess what? They
loser that
cannot
you need
fuck
to
us.
blame everyone
That's
else
why
for your
Ed
failure.
Wokeness said,
That's
it's a
the
really good
guy.
day if you're a popcorn company. Because, one, I think there's two meanings to that. And Wokeness said it's a real good day for popcorn companies. Because there's two things going on. One, people are watching the Elon and Trump bullshit go on. And then two, we have this going, right? And they know, everyone in the stock market, everyone in the world knows that this is going on at this point, but none of them really understand it like we do, and some people really understand it.
You
and
don't
know who those
understand it.
people are
That's
'cause
the
they probably
problem.
understand this,
You have
because they
not a
probably follow
fucking
the videos,
clue.
They probably have discussions. In fact, the people on X with all these major accounts are probably part of some major operation. If you don't understand that by now, they are in mainstream media. The people who get like their like, you know, their high level status, the I'm a pro support of Trump and I've got 1 million followers, and who knew who the fuck these people were? How do you get 1 million followers? How do you get $100,000? How do you get 150? You don't say anything meaningful or intelligent. You just fucking cheerlead.
Says the guy who cheerleads a insolvent theater company.
How did they get that status for being cheerleaders? Because someone gave it to them. They are propped up parts of government. They are the new mainstream media. They are infiltrators of our mainstream media, or of our
Oh my god.
grassroots movements
This
here
guy
on
is
X.
literally
Okay?
insane.
And there's a reason why truly authentic
It just
people
gets worse and
can't
worse. Him and
climb
Michael
rapidly
have gotten
in followers, but certain
increasingly
people
unhinged
are
and
having
insane
interviews with
the
Elon
baggier
Musk,
they
who
get.
Nobody ever fucking heard of before, and all of a sudden they have the shittiest interview skills ever, and they ask the same mainstream media questions. It's because they've infiltrated and they've propped up their puppets in X and Facebook and Instagram. Who they want to be popular will always be popular. They choose who gets popular and who gets a voice to be heard and who amplifies the messages of the people in power. Okay? It's not going to be us. Okay? That is why we're sitting here at 3,000, 4,000 followers, and stupid fucking people are sitting here with hundreds of thousands.
Wow. Bitter. Super fucking bitter. Nah, it's not that you're a conspiratorial neo-Nazi fuckwit with no talent. It's that no one understands your talent. And if it wasn't for them, if it wasn't for those kids and their stupid dog, I'd be more popular than them.
Because there's nothing meaningful about what they have to say, so promote the meaningless bullshit.
Ooh, again, coming from a guy who got bagged by investing in an insolvent theater company. Hey, look, Chris Soika wants to tell you how you're an idiot, even though he's the biggest fucking idiot of them all. Preach.
As fucking high as you possibly can and let people believe whatever the fuck they want, as long as
Again, talking about people getting high and acting as if that he has some moral superiority of them, while he's taking at face value the word of a guy who who is a proven drug addict known as Elon Musk. Jesus fucking Christ. Self-awareness zero.
it isn't the guy telling the truth. This is the truth. This is the reality.
It really
This is
isn't
your
the truth.
This is
No,
your company,
it's not.
and this is what your company's fighting for. And whether you knew
Your
it became
company's
a
not
vehicle
fighting for
for
anything. It's
success
a
for the
theater
American
company.
people and the American
Like
public.
this isn't some war or anything. This is a theater company designed to make money. It does not fucking care about you. If the reverse split and massive dilution of your shares wasn't an indicator, the only thing it cares about is staying afloat. It could give a fuck less about you, and it will continue to throw you under the bus again and again and again as many times as it needs to. They're like financial markets and companies are amoral. Like, the point is to make money, and if you don't make money, you go out of business. This isn't good versus evil, right versus wrong. This is finance. If you want to go play your make-believe war where you're fighting against the evil empire, you know, I can go get you a D&D book. You can go play your fantasy cleric role that you think that you're doing in real life. But that's not what's going on here.
Class Americans, whether you knew that or not, doesn't matter. You know it now. Okay, this is it. This is the only play. This is it. Oh, well, what about GameStop?
It's not.
GameStop has $5 billion in cash, and they sell video game consoles. But guess what?
Yeah, and they actually make money. I mean, they may not be operationally profitable, but they at least make money, which is more than can be said about AMC. But of course, he needs to deflect from that.
And God bless them. I hope they make money. But it isn't this business. This business
Oh, it isn't this business though. Like, isn't this the same argument that the GameStop marks make? Oh, yeah, sure, these companies are good, but they're not GameStop. Fuck off.
Week, month after month, for the rest of time. As long as it can get its debt reduced and paid down, it can go into the future making profits for the shareholders with just the support of people going to movie theaters, buying popcorn and drinks, grabbing chocolate off the shelves, all of that good stuff.
Oh, hi.
supporting the merchandise, grabbing shit off the merchandise shop, all of that
He
stuff.
forgot
gets
his
the debt
slogan
paid
there for a
down,
second.
Which gets the dividend rolling in, which strengthens the AMC Army of Apes, which makes us even more capable of funding high-croft operations and getting more gold and silver, which is real money, which is going to continue to rise as long as
His
pieces of shit
stupid fucking conspiracy
because
theory.
they're going to print it.
Amazing.
So no matter what, we are whether they fail or not isn't. They're going to try every time to socialize.
He almost lost the plot there. Whether they fail or not, it doesn't matter. Wait a second. Even his dumb brain skipped a clip there.
by running the money printer. So they'll try and buy your gold and silver from you by running the money printer and giving you that money by diluting the money supply and weakening the power of the dollar, right? But people are waking up to that and they're buying physical gold and silver again, and
Sure.
states are now passing bills saying that silver and gold are now forms of currency.
Where? Cite. Oh, no, I said the word. I said the word. Where's that? Text. Haha. That's kind of big. Select font. Can we make it like, I don't know, we'll make it 26. Arial's okay. Oh, that's way too small. First of all, let's make it 72. Is that okay? Yeah. Take it down here. Awesome. Change the color maybe. We'll make it AMC red sort of. There. And we'll put it back up here. There we go. We got Chris Soika's favorite banner. Citation needed.
And transactionable currencies that can be used, Tennessee, Florida, Texas, Alabama, Georgia, all those good southern people who have a fucking
yeah, I think that can go without comment.
brain have woken up to this reality. West Virginia, South Carolina, some of those, they understand. These people are printing money and they're not American. Okay? This isn't America doing this. This isn't Americans. This isn't,
If he actually understood the monetary system, he'd understand it is Americans printing the money. And they're printing the money because the United States is the world reserve currency and they need enough of it to go around to basically make the entire economy operate. But, that's a bit too high level for him.
Tim from the South who thinks it's a good idea to run some. This is some banker who's the most un-American, anti-free speech piece of shit in the world. Some media conglomerate who wants to control us. That's all these people are, and they just keep printing the money to disenfranchise us from our land and our country. Okay, they're just
According to who?
and we've let them because they've compromised our presidents, our congressmen, our statesmen, because they can't keep their dick in their pants.
Well, I don't think you have a problem with keeping your dick.
I
in
admit
your
I'm a
pants.
really bad person.
I think that goes
That's why
without
I don't
saying.
care when people throw shit at me when I'm in space calls. When you're like, oh, when you were 15, you fucking made fun of a kid with 5 fingers and you had 6 fingers at one point, but he had a stub at one point, and you made. I did.
It's not what people in space calls are making fun of you for. It's for your jiggling fucking man titties. But that's a little too embarrassing to bring up now, isn't it?
And I'm sorry. And I was bad. I'm sorry. I do a lot of stupid
You're
shit.
not sorry.
I
Don't
did a
pretend
lot of
like you
stupid
are.
Shit in my childhood. I fucking, laughed at the way people dressed. I laughed at people who had goofy glasses.
still
and
do,
I laughed
I
at
bet.
people who had fucking goofy hair. And I laughed at fucking a lot of stupid shit. I'm a really fucked up bad person. But guess what? At least I own it. Okay? Donald Trump couldn't own the fact that he went to fucking Pedo Island.
No, yeah, you owning that you're an asshole doesn't mean shit if you don't fix it or change it. And your shitter feed is a brilliant example of that. You're like, you owning that you're a shitty person. Good. Glad you can admit you're a piece of shit motherfucker. Now, either fix the fact you're a piece of shit motherfucker or go jump off a bridge. One of the two. If you're not fixing the fact that you're a piece of shit, that doesn't change anything. You're still a piece of shit. Like, what part of that's hard to understand? Just because you admit that you're a fucking prick, it doesn't make you not a prick. Stop being a prick.
Or fucking, you know, sex slave island and got caught in a honeypot. And now this is where we are. The entire government is caught up in a honeypot operation. Canada put Mark Carney in there. He's a pedophile. Keir
Citation
Starmer
needed.
is a pedophile.
He's lucky that Chris Soika is lucky at his level of anonymity here that he doesn't catch stray lawsuits for being a dipshit. Pretty sure that's the definition
The guy
of
from
per
France is
se
married to a dude
defamation.
30 years older than him who was a pedophile. Our countries are compromised. Europe is compromised. The United States is compromised. Canada is
According
compromised.
to you?
They pushed this in. These are honeypot operations to control our elite, to disenfranchise the people of those countries, and then flood them with fucking communist immigrants who are like, give me.
Communist immigrants. What even?
Gimme. I want more. You should pay for it. I want more. You should pay for it. Stolen land. It's all stolen. You guys took it from me. You owe me something.
Yeah, because you just totally don't leech off other people. Sure. Cool story, bro.
Those are the people coming here, folks. And it's by design that they're flooding them in. That's their voter base. Because guess what? They have no choice.
On this because I was
If you
super
got
slow
caught
in
fucking a
digging around.
kid on video, you already have no vote.
Okay.
So why not just
Sure.
sell out your entire
Took an
country?
S.
If they're gonna fucking give you the fucking gas chamber or the death penalty for fucking a kid, you might as well just sell out your country and live the fucking lavish lifestyle. Hey man, I fucked a kid and now I get to be driven around in a limousine, flown around on a private jet.
Why are
All
we
I
on
had to do
this
was sell out
topic
my country and I
again?
could fuck as many kids
I
as
thought we were
want.
here to talk
But-
about AMC.
But if I don't sell out my country, they'll expose me for being a pedophile. I'll go to a jail cell. They'll beat the fuck out of me, probably kill me, and I'll end up dead in a year. Which one would these people take? These people would have no, because they have no honor, they have no integrity, so they all are going to sell out their country. They're all going to sell out their country.
Man, you ever looked in a mirror
Okay?
recently,
They're all
Chris?
gonna do it. None of them have an ounce of fucking integrity in any of them. And they never did. That's why they became politicians.
Someone's envious.
Soika for president. I'm running in 2028. Soika for president.
Yeah, let us know how that one works out for you, bro. Oh, I gotta pick my CL. Yeah, let's do Colin. Let's do Colin because that seems silly. Colin is so fucking busted broken. Yeah.
The Revolutionary Party. We're gonna get rid of the entire fucking dick wagging government who can't keep their fucking dick in their pants, who compromise the country. We're just gonna get rid of all. You're all fucking gone. Chris Soika is president. You're all gone. You're gone. You're gone. You're gone. You're gone. You're gone. You're getting hung. You're going
Bigot
to
for
gas
president,
chamber.
ladies
You're
and
gonna get
gentlemen.
fucking shot,
It'll
execution
make the
style.
world a better
We're gonna
place.
fucking have you in a fucking-
Bigot for
we're gonna have you
president.
march to death
You
in
know
the
it.
desert, all that shit. We're gonna make an example out of people who sell out their fucking country for treason.
Oh, he's gonna make an example of you guys.
Eye for an eye,
Better
no
watch
eye.
out. Fuck
Do
you.
eye jokes. We don't do fucking eye jokes. Eye for an eye. We do tooth for a tooth around here, okay? Anyways, march them all out execute them all because they're all compromised. They won't give up
Just-
the list of the people.
Glad we got to the neo-Nazi point. Anyone I don't like, I'll just kill them. Fuck them. Glad you got that out, Chris. Glad you got that out so we could see the real Chris Soika. Get it all out of your system. If I disagree with you, straight to the gulags with you. We got a gas chamber waiting.
People who fucked kids on an island, all right? And these are the people controlling your government and running the money printer to disenfranchise you. So you
Speaking of which, if he's going to make that assessment for, like, pedophiles, there's a reason why we don't have the death penalty for pedos. And it's a logical one. And it's been stated plenty of times for the government. Because by the government or literally any law enforcement person, if you make it the death penalty for killing a pedophile, what do you think they're going to do to the child to prevent from being caught? If you marked on your answer card, kill the kid, congratulations. You now know the answer. Why we don't have the death penalty for pedophilia. Jesus Christ. This is why fucking idiots like Chris Soika, like, don't have any sort of grasp on reality whatsoever. Because they don't have the IQ score to remember to breathe without being fucking told to do so.
can't have a good life so that you can pay for their yacht and their fucking private jet so that they can fuck a kid on an island. This is where we're at. Yeah, I know. That's right. Fatigue is real. We got pedo fatigue, babe.
What?
We got pedo fatigue.
Jeez, God.
We got sex trafficking fatigue. We got elitist fatigue. Ghetto fatigue.
I think you've got a serious problem, my dude, if all you think about is the secret pedos in your closet. I have to seriously wonder, are you, like, you're so fucking obsessed with it, are you, like, do you like little kids, Chris? Is that what the problem here is?
It is what it is, and if you want to fight back monetarily, this is the way to do it. This is it. This is our last bastion of financial freedom.
AMC is our last bastion of freedom. Oh my God. No.
It will work for you. It will work for you for the rest of your life as long as you support it. There's no way we can bankrupt it as long as you go to movie theaters. How many shares you have is how many shares you'll get paid worth of the profits. As long as you're willing to pitch in, collectively come together and pay off the debt, you'll be paid for the rest of your life, and you can keep accumulating. If they want to keep it to $4, who gives a fuck? If they want to take it to $1,
I'm gonna guess.
The key to this whole game.
Say no.
Okay? If you have, again, a $4 stock, okay?
It's not $4. It's $3.
$1 dividend, which will never happen, but in the event that it does,
I'm glad he's at least admitting that it probably won't happen. Oh. Well, that's
you
mean.
would have a 25% dividend, by far the highest dividend in the world. Okay?
Okay.
Now, how do you justify this price? You can't. So in order to stop giving away a 25% dividend, you drive the price up to make this a 5% dividend. Okay? And that would be 20. So this goes up to 20, and now this becomes a 5% dividend. Okay?
What?
So all
Are you fucking smoking?
Would have a $16 gain, which is a 400% gain.
Hey,
Plus your dividend. What?
Elon just said he'll put money on it that is true. That's crazy.
I mean, of course. I mean, we all kind of knew it when they didn't fucking do it on day one. You know? In the back of our head, did we not know? Did we not know that fucking something was wrong when Pam Bondi threw her fucking...
Little stuff
That big charade.
Are we still talking about that?
She doesn't do
Oh
shit.
my
She doesn't
fucking
do
god.
anything. Get her fucking out of here too.
I thought this was about AMC, not a. I mean, at this point, I should know with Chris, it's about his fucking delusions of grandeur, but like.
Democrat, Republican, you're all fucking compromised, pedo, fucking leftist, dorky, elitist traitors. You're all weird. And the American people don't relate to you anymore. You're all fucking terrible.
He just can't help himself. He just can't help.
Well, the truth already came out. It should have been recognized a long time ago that these people were fucking around. $4 to $20, $1 here. You know, this becomes a 5% dividend, which is still fantastic.
Oof.
You still add a 20.
That sucks.
But you have to remember, if you continue to go to AMC and drive revenue into the company, you can build new revenue
What
streams.
was the point of that
Production
swap?
shares and
I'm
streaming
not
sessions
sure.
means the value of the company
But
will go up
I
because you're able to pay
probably
yourselves more money.
should
You can
try
build
to
new revenue
keep him
streams
from
by
getting
continuing to go to AMC theaters. AMC
Let's
can
see if
be
we
that
can.
machine
There we go.
for the American people to generate wealth.
Slow
for the
him
next
down
100
just a
years.
bit.
It doesn't matter what they do. It can be T-shirts, it can be socks, it can be underwear, it can be white T-shirts. This company can sell anything back to us, and if we support it, we're gonna make money. We can sell toys. We can
Never
sell
mind, sunk
popcorn
cost
buckets, we can
fallacy.
sell, hats,
Look, if we
white
just give this
stars,
company, this
mittens,
soulless company
socks, we
that's
can sell
fucking
all of
pounded
it.
our investment into oblivion,
We
we'll
can
just
buy
get
all
rich.
that stuff
Trust me,
because we
bro.
work for a living. As long
Trust
as you
me,
have a job
bro.
and you work, and as long as you drive money into this company and pay down its debt, which it is getting close to.
Why do
paying
you need to
down a
pay down its
significant
debt?
portion of.
Like, who are
You will
you?
make
Are you
money for
some
the rest
like
of your life.
fucking slave?
Able to stack
I thought you
shares,
didn't like
so
that,
you're
Chris.
making money. Now remember, a $1 dividend is beautiful, but this is all about earnings per share. That's the next thing we need to talk about in this whole thing.
Oops, clicked the
We
wrong thing.
need to talk about the big thing, okay? The big thing is gonna be earnings per share. This is gonna dictate
I'm
the
so
value of
glad
the
you
company
targeted that. Thank
for the
you.
next 100 years. You will follow it exclusively.
That's
I remember
not what I wanted
when we
to-
were losing $2.50 a share. Okay? I
That was
remember when we
dumb.
were losing $1.60 a share,
They're gonna
$1.50 a
switch
share,
CEOs.
$1.20 a share.
Okay.
Now we lose a penny or 4 cents a share, and people go, "Ooh, this is the end of the world." It's not the end of the world, folks. It's not. We used to lose hundreds of millions of dollars during COVID.
And you still
We're
do.
losing pennies per share. Pennies.
Because he diluted the fuck out of you. You're still losing hundreds of millions of dollars. The only reason it's an EPS of pennies is because Adam Aaron diluted the fuck out of you. You can't use one metric and then switch to the other just to make your argument more convenient. You're still losing hundreds of millions of dollars. Fuck. God, this dude is so fucking retarded.
Okay? And we make up for that by having earnings per share the following quarters during hotter quarters, right? So what's going to happen here? In Q2, all right, we've already talked about this. You have about $75 million from the first initial weekend, okay, which isn't a weekend, it's a Sunday. So it's a little bonus, okay? But you have 4 weekends, okay? You have 4 weekends of Thursday, Friday, and Saturday. You've got 4 of these, okay? Times 4. You've got 4 weekdays, okay, which you're already starting, right? So you have Monday, Tuesday, Wednesday, and Thursday. Now, you already have 75 in the bank. In order to get to $3 billion, you need to make $1.1+ billion. And you already banked 75 from your first Sunday. And that is not with a good weekend, okay? Karate Kid did not do well. It wasn't a great release. It just flopped at the movie theaters, and it's okay to admit that. Lilo and Stitch continue to do well, but we need something to carry us this weekend. Okay?
Mhm.
So this first weekend, we're hoping, okay? We're hoping we hit this 100 million going into the weekend, right? And we're hoping this weekend to get $150 million. Okay? We're hoping to get $150 million weekend. Okay? Now people say, well, I don't know how much people are going to do. Is Karate Kid going to do any numbers? Is Lilo going to do any numbers? Is this going to do any numbers? It matters not which movie does it, but that we make it to that number. We want the domestic box office at $150 million. Okay? Now, we get to this number here, right? We push the movies this weekend. We go and see Ballerina, and we get this up to 150. That puts us at 225. Okay? That puts us at 225. Now, we have another weekend, or another week, right, at Ballerina. And then we have our big movie, How to Train Your Dragon, which comes out after that, okay? So, we're hoping for, right, we're hoping for another, 65 million in week 2.
Hoping.
We want 65 million here, right? But on How to Train Your Dragon, we want about a $200 million weekend. And this is because we still have Ana de Armas doing her thing with John Wick. We still have Lilo and Stitch getting some value, but we really need to push How to Train Your Dragon so we can get that $200 million weekend. Now, as you start to add this up, you're like, okay, now we got How to Train Your Dragon running. We still got Lilo and Stitch running. We still got Ballerina running, right? You want to make about $75 million during the week. Now, I think we're going to be much higher than this, guys. I think we're going to be much higher than this Monday through Thursday when this stuff starts to take off. I think we're going to be around 80 or 90. But this is how this works. So when people say we're not going to hit $1 billion, don't believe them, okay? Now you've got How to Train Your Dragon, Lilo and Stitch, and Ballerina running, and you're going to run into Elio and
Yeah, now I can build areas. Thank you.
28 years later, okay? Now, the Phoenician scheme's coming out. I don't think people really know about it, but it could do, 5, 10, 15 million, in a weekend for opening weekend. I don't know. I don't know how it's going to do, but it looks cool as hell. Benicio del Toro is amazing. Wes Anderson's the director. I don't know who's going to fucking go see it because they didn't really promote the movie, but it looks fantastic, and Benicio del Toro is a great movie. Now,
When they do that, they want original films, the audience does, and then
yeah,
they don't promote it.
it absolutely sucks. But that's how studios work, right? They only promote their bangers, and then they say, I don't know why people don't go to the original movies. So here you are, you're going into How to Train Your Dragon, 28 Days Later, and Elio. Now you're hoping to get like 225. Now people say, well, why would you get 225 on this weekend? Because remember, How to Train Your Dragon is going to be hot. You're still going to have some Lilo and Stitch. You're still going to have Ballerina. You're going to have all these movies.
What are the odds that all these numbers he's pulling out of his ass are incorrect and won't happen?
And there are big names coming out. And How to Train Your Dragon, plus 28 years later, plus Elio, is going to move some numbers. And we need to support these movies in order to get this. We need to get this. Now, I think if you add these up, right, you got that.
Oh, you think?
$65
I don't know about that, hot shot.
You're already starting off with.
Something tells me you don't do a lot of actual thinking.
You need, another 75 million here. So you got your opening, and then I believe. Hey, I need your phone. You gotta look at your camera.
Well, at least I will give him this. He's better than number one cut John Hartnett. He'll at least get a calculator to do calculator math as opposed to outsourcing it to Grok.
Okay. So the 27th, the 28th, and the 29th, and then you got a Monday. Okay, so the Monday is just the bonus. Hopefully we get in, drive another $20 million into the box office to start July, which is July 1st, and then obviously 2nd, 3rd we get Independence Day.
Yikes.
Like that. So hopefully
That's
we can
gonna
get
really
the
suck
fourth
for you.
July, taking time off and going to
Yeah,
sleep.
let's
But
do that.
if you add this up, you've got about, this is $775 million, right? This is $775 million, 150 here, that's, 875, 925, and then, 925 plus this, so you get like $1.06 billion. And I think these numbers are shy in this area. I think these numbers
You
are
think?
shy
You
in
got
this
any
area. I think
sources
we
to
could
back
use
that up?
$25 million days.
There's just a really
after
big
How
you
to Train Your
think.
Dragon comes out. I think we can do a Monday, Tuesday, Wednesday of $25 million. I think we can do a $25 million Monday, Tuesday, Wednesday with How to Train Your Dragon and 28 Years Later and Elio and all these movies out. I think we can do 25, sometimes 28, 29 million on a Monday and Tuesday, and that's because the summer months. My kids at our school are not out in Chicago. They're not out of school yet. They have school until Friday, so not all the kids are out. It's June, yes, I know it's late, but up here in the north, in Democratic-run cities, they need to indoctrinate the kids as long as they possibly can. If they
He's still gotta get that in, doesn't he? Oh, they're indoctrinating our kids.
So,
These dumb fucking Democrats.
right? Once these kids get out, you'll see the weekdays start to tick up a couple $1 million because this is what they do. This is what college.
It's the conspiracy to keep his near bankrupt movie theater company from being profitable is the damn fucking Democrats. God damn them Democrats. That's how they keep them poor. By trying to bankrupt the AMC.
Sometimes we can't get $100 million.
Oh my goodness.
There's no reason. So again, if we execute here, right? If we execute on Ballerina and get our 150, maybe more, maybe 165, we get lucky. If we get 200 million for How to Train Your Dragon and Ballerina, we're doing well. If we get 225 for How to Train Your Dragon, Ballerina, How to Train Your Dragon, Elio, and 28 Years Later, we're doing really well. And if we finish with Megan and F1, Elio, Ballerina, and all the June releases, if we get a $200 million weekend to close June, we're
You served us
killing
well.
it, okay? Because we're gonna get a good Monday, maybe an extra $25 million from the Monday, because you're gonna have all these movies out, okay? So everyone's saying, oh, well, you don't track the days. This isn't February. We don't do $6 million days here. We do $20 million here. We do $20 million days here. Okay? So don't.
That sounds like price anchoring to me.
Being $1 billion. Go look it up. Every fucking June is $1 billion pre-COVID. And these movies are just as big as.
Assuming that they're gonna get to there, like again, still have not gotten back to pre-COVID numbers. Kinda saying that, like hopefully it gets there, I guess, but like no guarantees for sure.
Anything that's ever come out in June. And the kids are out of school. It's the setup is here. You guys should be ready to go. And guess what? You can sweeten this. You can sweeten your investment. You can fight back with your investment. You can go fucking hard with your investment. You can accelerate this investment by going to the fucking movies, driving in extra revenue, buying
Sunk cost fallacy returns.
a towel, buying a fucking hoodie, buying a sweatshirt, buying a piece of merchandise, buying some extra chocolate and giving it out to the neighborhood and letting them try it, signing up people for A-list. This is still.
Oh yeah. Getting chocolate and speaking of sunk cost fallacy, oh my goodness. I'm gonna have the search bar back. Where is it? Boom! It's like it knows I'm looking for this dumb motherfucker. Where was it? There's a reason why he mentioned going out and getting kids to buy fucking chocolate. Where was it? Because this doofy motherfucker went and bought a whole bag full of chocolate from AMC. Like, Is it really this far back in his timeline? I mean, not even. Oh yeah, Andrew Tate. It'll be really fun watching the tears he bleeds when Tate goes to prison. Oh, here it is. Boom. Imagine buying all that shit at a theater. Amazing. At some inflated theater cost. Not working out well, I bet.
Fucking movies you come out. Do you want your
Why did you flip it back to... Oh. Probably because my headphones died. Oh, gotta go to the gamer headset. Not that one. This one?
fucking neighbors and friends?
That didn't work.
Going to Marcus Theater?
Well, I'm sure you guys hear it because desktop audio works regardless
A-list
of...
those fucking people. Get them A-listed, and they're gonna know.
Well, now I gotta fix the mixer again. So I had to flip my... Oh. Okay.
All of these movies, they're gonna go to Superman and Jurassic Park, and they're gonna spend money on your popcorn and your drinks and your chocolate.
Your, as
This
if
is the
you
most important
own
thing to
this.
do is
No, the
get
company owns it, not you,
loyalty to your
dipshit.
company.
It is not your company, legally speaking. A company is its own sovereign entity. You don't own it, technically.
What's a $75 investment in a
Biggest
neighborhood
lie
that
told the
two-
shareholders
or
that they
a
own the
guy on your
company.
baseball team whose kid you play baseball with, and you're like, yeah, let's go to the movies, let's take the kids, and you fucking get them an A-list. You know, what's the big deal? This is how you generate business. This is how you bring in loyalty and rewards to your business. It's all about generating business so that you can have the financial freedom to escape this fucking nightmare of a fucking government and just do what you need to do. Okay? Because they are not helping us. We need to help ourselves. We need to fight for ourselves, and this is how we do it without picking up guns. Okay? So that's the video today. We are fighting a multi-front battle. We have the best leadership we could possibly have in Adam Aaron. The board is doing an excellent job, but we are doing an amazing job as well. Keep going to movies. There's some people in this movement that constantly post pictures, constantly post their merch, constantly post their fucking food. And you guys are the heart and soul of this movement. You guys drive revenue more than anybody. You guys fire up everybody, and we feed off that here. Heather all the time sees other people doing their part, and she always is like, come on, we got to go see Karate Kid. And I'm like, oh, I just got home from work. And she's like, come on, we got to go see Karate Kid. And I'm like, and I did like it actually. So I got my ass up and I said, all right, I'm going to see Karate Kid, and I actually really like the movie. So it's one of those things where, you know, yeah, it is. It's like going
I
to the gym,
can't
but it's also like,
imagine.
you know, putting effort into your business and growing your business. And
It's
getting to
not
pay
your
down debt,
business,
right? You
and you're
gotta
not
go and
crying.
work at it,
Like,
guys.
again,
And,
sunk
she did a
cost
great job of keeping
fallacy
me honest,
is...
because sometimes I just don't want to go to the movies. I don't want to get up. I have a, you know, I work and I get up at 5 in the morning and I come home and I don't want to go to a movie, but I do, and I go by, and when I'm there, you know what I do? It's like going to the gym.
Imagine
It is
being
actually
this
like
much of a
going to the gym.
corporate
I do some
slave.
extra reps because I'm
Good
once
little
I start
bitch.
feeling good, I start buying some extra chocolate and buying
Consume, Chris
some extra
Soika,
drinks and giving some gifts to
consume.
the people behind the counter, and oh hey, there's a kid in line. Hey, do you like any of these candies? Here, I'll pick it out for you. It's free. Here, this is courtesy of an A-list member. Oh, you don't know what A-list is? Oh, it's free. I get the movie for free, so I just buy popcorn and chocolate for everyone else. And they look at you like you're crazy. These
'Cause
people,
you
how
are
crazy did that lady look
crazy.
at us when we did that?
I mean, very crazy. She said no multiple times, and then the kid was like, yeah, I want that.
Yep. The mom said no, and the kid was like, I'll take the free candy. She did. She caved. But it's cool.
It's just the culture up here, too.
Yeah, no, I mean, it was cool. I mean, it worked out. But, yeah, the thing is, we just keep giving it.
Cults.
You know, we try to buy things for the company and give things for the company and help people get involved with our company, feel good about our company, feel good when they see movies at our theaters, so that they can feel that experience, so that they can grow an attachment to our movie theaters. And realize just how great of a business this is. We're not snake oil salesmen. We are
Trust us, bro. This isn't multi-level marketing. Trust us, bro. When you need to lampshade your shit, again, when you need to lampshade your shit, that should be the first sign that whatever follows is a fucking lie. Self-awareness, zero.
selling the best entertainment in the world, okay? Tom
Are you,
Cruise
though?
is in a fucking plane on the side of a single engine plane doing fucking stunts, hanging out of
Yeah,
a
but I
plane.
can watch that at any
There's
theater, not
submarine
just
shots that
AMC.
are unbelievable. Fighter jets flying around, and you're paying $14 and complaining that it's too expensive. Guys, these people are putting $200, $300 million into making a movie and giving their lives and risking their lives to do some of
Okay.
these stunts. Just be a little more appreciative when you.
Yeah, when you get gouged at the movie theater, just be more appreciative, dude.
Say the fucking prices are too high, okay? But that's the video for today. Keep fighting, keep going to the movies, keep buying popcorn and drinks.
That should
Don't
be this
forget to fucking,
self-righteous about
hey
an
man,
insolvent
silver
theater
can move
company.
drastically from this point on. So, you know, congratulations to all my silver stackers out there. Whoever was buying silver, you know, I know it's only $1, but you know, maybe $2 from where you bought, but it's making progress, and they still haven't closed out their physical short positions, and they're still struggling over there in the precious metals market, and that helps us. So you guys have a great day.
Sure.
2025 is shaping up to be a great year for AMC Apes. Everyone acknowledges us in a way without acknowledging us. They never actually say anything. Yeah, they nod to AMC shareholders as some
Sure.
people in the world.
Cool story,
Because they
bro.
constantly say, oh, stuff about popcorn and all this other, and people say, oh, it has nothing to do with it. No, it does. It does. People recognize us. People know about us. That's why they silenced hashtags and silenced our movement and silenced the Bud Harris thing. Everybody knows
more.
us. It's our fight now. And if people don't know, that's their own problem for being ignorant. So you guys keep battling. Let's have a good day. Let's go see some movies.
Anyway, that's it for me this evening. I'll see you tomorrow night for the actual Truth Be Told episode. I think Ocelot might be joining us, but we'll definitely have Platinum and Amy there. So I'll see you then.